Who's here that I can? Thank you, everybody. Please be seated. I'm welcoming you today to the tonight, I should say, West Hollywood Planning Commission. It's Thursday, April 19th, 2018. This is a regular meeting, and I call the meeting to order. First item after the call to order is a Pledge of Allegiance. I understand Bob Burke is in the auditorium. Could you come up and lead our pledge?
Thank you. Ready? Begin. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you.
Mr. Secretary, can you call the roll, please?
Good evening. Commissioner Hoopengarner.
Present.
Commissioner Carvalero.
Here.
Commissioner Bass.
Here.
Commissioner Elchel.
Here.
Commissioner Guy.
Here.
Vice Chair Jones.
Here.
Chair Buckner.
Here.
And we have a quorum.
Thank you so much. Moving on to item number 5, which is approval of the minutes. That was for the May 3rd, of the April 5th meeting, right? So we're asking, oh, excuse me, I'm sorry. Approval of the agenda, I checked it off without even realizing it. Do I have a motion for approving the agenda for tonight?
A motion, Vice Chair Jones, seconded by Commissioner Guy. Agenda is approved, unanimous.
Thank you for correcting me. Next, we move on to the approval of minutes of the prior Planning Commission meeting. I understand that they weren't quite ready to move onto tonight's agenda. We're going to continue it to May 3rd. Is that correct?
That is correct.
Do I have a motion for that?
Motion, Vice Chair Jones, Commissioner Bass seconded.
Any opposition?
And motion carries unanimously.
Next item is a public comment, and do we have speakers?
We do. We have 2 public speakers. Our first public speaker is Richard Giesbrett.
Richard Giesbrett, President of West Hollywood West Residents Association. You should have received a letter of comment from West Hollywood West about Bottega Louie and some concerns we have about the acoustical reports. We have concerns about the scope of those reports, which we feel are faulty, at the conclusions of those reports, and who evaluates those reports. And we would like you to think broadly about the circumstances surrounding Bottega Louie, and more importantly, protecting West Hollywood Park, so from incursions from commercial development around it. So if you will simply pay attention to those things, first and foremost, we'd appreciate it. Thank you.
Thank you. And I believe that we're going to have a little report on that later on in the evening tonight. And we have another speaker.
And we have one more. Our last speaker is Genevieve Morrow.
Genevieve Morrow.
Guess I knew that. Good evening, Madam Chair, Commissioners. Genevieve Morrow, President and CEO of the West Hollywood Chamber of Commerce. I wanted to invite you to our West Hollywood State of the City 2018, which will be held on June 14th from 6 to 9 at the London. And each year we have a theme in mind, and it usually goes hand in hand with who the mayor is at the time. And this year the focus will be the Sunset Strip. We're working on the programming right now with economic development and the city, and we invite you all to attend. Thank you.
Any other speaker slips? Okay, then we'll move on to the director's report. Mr. Kehoe?
Thank you, Chair and Commissioners. John Kehoe. So I just want to give you an update on the appeal for 1227 Formosa that was heard by the City Council on Monday night. There's a lot of people at the City Council meeting speaking on both sides of the issue. Ultimately, the City Council both upheld and denied the appeals in part. And so ultimately what they did is they added a new condition to the approval addressing the Juliet balconies. And so I'll read what the draft language is for that resolution for that condition. The Juliet balconies on the first level of the south elevation shall be redesigned to include a window that is fixed to a height of 42 inches measured from the floor. The portion of the window that exceeds 42 inches of this to the ceiling can be movable. So basically that made a window that still provides a lot of air to be able to come in and out, but from 42 inches down to the ground would be fixed. It could not be open, and therefore they don't need to have any security railing on the outside of that. And so that was the decision by the City Council. And I'll be back later in the evening after the main item is over with to give a brief update on Bottega Louie. I'll be over there with the planning manager's comments.
You'll address that later?
Yeah,
in the
later
hearing.
during
Thank
planning
you.
manager's comments.
Thank you very much. Moving on to item number 8, items from commissioners. Do I have any commissioners who'd like to speak at this time? Seeing heads going this way, I'll move on then to consent calendar, of which there is none. And the next item is number 10, and it's a public hearing for tonight. It is the only item on our agenda for public hearing, and it's the appeal of 8500 Sunset Boulevard West Tower. I understand that the, I guess I could address this at this point, that the appellant has asked for additional time to do their presentation. It's an unusual request for the length of time that they're asking for, but because we only have this one item and because of the complicated nature of this particular item, I'm going to grant that request. So they're asking for a half an hour for their presentation. Do I have any objection? Okay.
Sorry.
All right, let me hear your, how many people object, so would be opposed to it? 3. And how many of
I'd be
us are-
willing to extend the time, but not triple it.
Okay, how about 20 minutes? Is
I'm
that-
fine with that.
Everybody's fine with that? Okay, we'll do it 20 minutes. I hope that the appellant will be prepared for that. Thank you very much, and we'll move on. We have a staff report.
Good evening, commissioners, members of the public. My name is Rachel Diamond. I'm a senior planner in Long Range and Mobility Planning Division. Tonight before you, we have a zoning ordinance interpretation appeal that is related to 8500 Sunset Boulevard. A little bit of background on the project. In 1999, the city entered into a development agreement with the former owners of this project to develop 3 parcels, the east, middle, and west parcels. The west parcel is now known as Sunset Millennium and was developed as part of that original 1999 development. And ultimately, a restated development agreement was approved by the city in 2005 that essentially established the development rights for both the middle and east parcels. The middle parcel is the subject parcel that we'll be discussing tonight. As part of that amended and restated development agreement, there was an associated EIR that was certified, as well as a number of permits as part of their entitlement, including development permits, demolition permits, tall wall, and sign permits approved by the City Council. As part of that 2005 development agreement, the subject middle parcel was approved to include condominiums as well as retail on the ground floor. In 2012, there were a number of amendments made to that approval that's included in your packet this evening. And specifically, there was a reference that was added to allow for those condominiums to also be utilized as apartments, which would change their vesting tentative tract map at the time and ultimately reflected in their final map that was recorded in 2017. Excuse me, yeah, 17, thank you. In January 2017, there was a certificate of occupancy issued for the project. Ultimately, the residential units were left vacant at that time, while there were additional tenant improvements that were being done on the property. There were a number of changes made to the units, and then the retail components of that project were subsequently developed and are still some under construction and some are occupied at this point. In June of 2017, the city was notified of the potential use of these residential dwelling units through an article in the LA Times, which was also included in your packet. And I think that is particularly of interest because that's what kind of started the ball rolling for this entire process that brought us here today. So ultimately, the city issued a zoning ordinance interpretation in November of 2017, again, also included in your packet. With some attachments that included emails and letters back and forth between the city and the developer to help the city understand what it is that the developer was proposing to do. So you'll hear a little bit about anticipated use at the time. In November, they were not operational, so the zoning interpretation discussed anticipated use of the property, but ultimately the project was operational as of February of this year, 2018. In December of 2017, just to take a step back, the appellants appealed the zoning ordinance interpretation, which basically said two key items. One is that the anticipated use of the property would be not for long-term use and short-term use, and also that they would be operating a hotel on the property, which would be in violation of the development agreement as well as the associated entitlements. So that's what brings us here today. We have a zoning ordinance interpretation that was issued by the director in November of 2017. That was appealed, and we're here at this hearing to discuss that zoning ordinance interpretation, and ultimately your determination will determine if that zoning ordinance interpretation is approved or not. So the interpretation, as I stated, the interpretation really dials in on the building being operated as a hotel, that the units are not rented on a long-term basis, which is in violation of the development agreement, and that use as a hotel was not contemplated in the environmental impact report, nor was it contemplated in the statement of overriding considerations that allows for a project that has significant impacts on the environment to still move forward. Ultimately, the use of residential dwelling units on the site triggered requirements for affordable housing, both on site and fees in lieu that were paid. Right now, there are affordable units that are identified in both the east and west towers of this middle parcel. And at this point, the units in the east tower of the middle parcel are already occupied, and the city is working with the developer to fill those units in the west tower that is the subject tower that we're discussing today. And just to kind of wrap it all together, ultimately this use as a hotel not being used on a long-term basis doesn't support the need for long-term housing in this city, which was one of the many reasons that this project was approved to help to essentially increase the amount of housing stock that the city has. So use as a hotel, and I'll kind of break these down as simply as possible. The code defines a hotel as a facility with guest rooms or suites provided with or without meals or kitchen facilities, rented to the general public for overnight or other temporary lodging, typically less than 30 days. The units are being rented to the general public with online booking available. There's also a front desk. You can walk in and book the units. They are serving as temporary lodging. Guests aren't establishing residency, so people are staying here on business. They're coming on family vacations, and generally not establishing residency in these units. People aren't registering to vote at this address, as an example. Perhaps they are in the East Tower, where the units are being rented on an annual basis unfurnished. These units are furnished and are being rented for 31 plus days. Essentially, the building is being used as an extended stay hotel to kind of help understand this type of use as it relates to other buildings. You know, extended stay hotels are typically for a longer vacation or business type stay. And it hasn't been a use that's been contemplated in the city of West Hollywood because this hasn't been something that's been the type of use that occurs in this market. So this is kind of something that we're seeing that's a little bit different, where we're seeing an extended stay hotel in an upscale market. So it's something that we haven't necessarily contemplated before, nor has anyone ever requested to do this type of use in the city before. The building offers front desk, housekeeping, room service through a yet to be opened restaurant on the ground floor, as well as a number of other amenities. Here's some screenshots just to give you kind of an idea of what happens when you're looking for AKA West Hollywood on the internet. Preferred hotels and resorts lists, they have one luxury hotel within West Hollywood, and it is the AKA West Hollywood. Again, I concede that they are renting these for 31 days or more on these sites, but as part of that, you can actually use your preferred resorts points and get free internet, room upgrades, priority early check-in, late checkout with every stay. So, you know, this property is being advertised and is being used as a hotel. Similarly, this gives you a little bit more information about the Prefer Hotel Rewards and how it relates to this property. And then you have kind of how the internet in general sees this property. I mean, here's a Yelp review, or not review, rather, their Yelp page. And it's listed as a hotel. And interestingly, I noticed, because Yelp does this, you know, they want you to pay to use your page. So this site has been claimed by the owner, by AKA West Hollywood, who certainly hasn't done anything to edit that it is considered a hotel on this site and is being marketed as such. This is Google's screenshot. They also view this property as a hotel and even have the ability to kind of check availability right through Google, as well as some nice reviews on short-term stays. This one actually is particularly of interest to me because it's a charitable website that they auction experiences, which is fantastic, and they always go to great causes. That being said, they are auctioning off a 3-night stay in this property, which is somewhat outside of what staff even understood their operation to be. They've contended that they have never offered anything less than 31 days, but for a charitable donation, you can stay for 3 nights. And one last one, also particularly interesting, is oasiscorporatehousing.com, where property 7081, aka West Hollywood, is listed for use by people who are involved in corporate housing. So a company can potentially use this website to help house their CEO short-term, which, as you know, corporate housing has also been banned in the city of West Hollywood, to be specific. So the other key piece of the zoning ordinance interpretation is related to the use not being long-term. So there is no definition of long-term in the zoning ordinance, so a large portion of that zoning ordinance interpretation was trying to help clarify what the zoning ordinance already says about what is long-term. So essentially we looked at a number of definitions, including dwelling unit, or housing unit, which talks about the use being for one household on a long-term basis. Again, without getting specific in that definition. So we looked to other definitions to help clarify, including transitional housing, which talks about temporary housing no less than 6 months. Additionally, emergency shelter is short-term housing, and it's limited to 6 months or less. And then we have corporate housing, which requires that the unit be occupied for at least 1 year, or that someone be using it as their intended domicile, right? So in this case, you're either declaring residency, or you're there for at least a year. So we looked at these definitions to help us, again, clarify, not create a new requirement, but just to clarify what is long-term. And ultimately, the zoning ordinance interpretation establishes that long-term is 1 year. Should this zoning ordinance interpretation be upheld by the Planning Commission, staff anticipates, based on the requirements in the zoning ordinance, that we would return to further clarify the definitions to make sure that that clarity is in the zoning ordinance, as is outlined in the zoning ordinance interpretation. So there's the third piece really to all of this, aside from that they're operating a hotel, they're not operating on long-term use, is that all of these things and the operation and use of the property is in direct violation of the development agreement and their associated entitlements. So rather than get into too much detail about this, this is a description of the middle parcel from that 2005 development agreement. And, the 2 9-story residential condominium buildings with ground floor retail and restaurant is the subject property that we're talking about. And I think it's particularly worth noting that the project was provided a 3.25 FAR in the Sunset Specific Plan, which designates a 2.75 FAR with a density bonus of 0.5 in the Sunset Specific Plan for residential uses. So all along, from 2005 on, the project was approved as residential uses and dwelling units within those 2 residential towers. And at the time, like I said, those were condominiumized units. Again, the development agreement allowed for up to 190 residential units. And there was an affordable housing requirement. As I stated before, there are 17 affordable housing units on this site. About half are in the East Tower and half in the West. The East Tower is already full, and the West Tower, the city is working with the developer to fill those units. Affordable housing is required for dwelling units. So you build 20 units, and you have to build 4 affordable units. It's a 20% requirement that is placed on residential units throughout the city. And if these units were not meant to be residential dwelling units, they would not have had an affordable housing requirement on them. Certainly half of that requirement was allowed to be paid in lieu, and that's what a development agreement can potentially afford you, and in this case did to the developer. But ultimately, if this was approved as a hotel, they would have a commercial linkage fee in lieu and not be required to build units on site. So the units kind of help understand, the intent of of the building as a whole as a residential building for long-term stay. Skip through a few things. There is a provision about minor changes to the project and what constitutes any minor change. And ultimately, there were a number of minor changes that were enacted in 2012, as I stated, one being the allowance and just clarification that while the building was approved to be condominiums, that they could also do single parcels for each tower and have them be apartments rented out to individuals and owned by one entity. Ultimately, things that are not minor are items that alter the permitted uses of the property as a whole. So a change like this that would change dwelling units to a hotel would ultimately be considered a major change and would come to the Planning Commission typically for recommendation to the City Council and then ultimately go to the Council for approval. None of that has happened. Essentially, the city issued a zoning ordinance interpretation stating this is not allowed on your property, and as a result, the appellants essentially ignored that and started operating their building after the zoning ordinance interpretation was issued in November. The environmental impact report, I think, is also really important to note here, and I won't get into too much detail again, but the environmental impact report, multiple volumes of thousands and thousands of pages, analyzed a project with 190 dwelling units. So there are very different impacts on the environment when you have a hotel than you do on dwelling units. So the environmental impact report on numerous occasions cites the impact of dwelling units and not of a hotel on this specific portion of the property. I think that's really essential to note that the project was evaluated based on long-term residential housing and not hotel use as they're operating today. There's also a number of mitigation measures, one of which I think is just relevant to bring up, and it's that the owner shall comply with this code section, which requires that all high-rise occupants receive annual instruction on procedures to be followed in the event of fire, earthquake, or other emergencies. Instructions for all new occupants shall occur within 14 days of their assuming occupancy of the building. If this was a hotel, this would not be a mitigation measure. Why? Because a hotel doesn't necessarily train all of their occupants on how to operate in the event of an emergency, which unfortunately happens here. And this type of measure would not be the type of measure that would be included in that type of document if these units were not anticipated to be used on a long-term basis. There are a number of objectives, again, that I've included in your staff report, and I'll just kind of run through a few fairly briefly. There are a number of objectives that were identified in terms of the proposed project, and this was all relevant to the EIR, certifying the EIR, and the statement of overriding considerations that was related to that. And again, the key piece is that this project was listed as providing needed housing stock for the city of West Hollywood, that it would enable the city to fulfill many of its objectives outlined in the Sunset Specific Plan, including incorporating residential uses on commercial property to meet the goals of increasing the city's housing stock. Again, use of this property on a short-term basis and as a hotel does not contribute to the city's housing stock. Again, there were a number of goals and objectives that were outlined, promoting the production of housing, developing housing, using this underutilized land for housing. Again, I went through this once before, so I kind of went a little bit quickly, but this building is being operated as a hotel. The units are not being rented on a long-term basis, and as such, they're in violation of their development agreement. They're in violation of all of the entitlements that were approved as part of this project throughout the number of years that staff has worked with them on this. This use was not contemplated for this specific location in the EIR and in the Statement of Overriding Considerations. This use also triggered affordable housing on site. Of which contributes to our arena numbers and our housing stock numbers and our housing element, all of which would necessarily need to be amended to reflect that these units aren't being used as housing. The use doesn't support the need for long-term housing, and as I stated, if the zoning ordinance interpretation is upheld, we would return in the future with a zone text amendment to clarify. With that, I'm available for questions.
Any questions at this time? How about down at this end? Okay. Yes, of course.
Just a couple
I know
quick
that.
questions,
Sorry.
Rachel. Did the applicant notify the city of the purchase of this property per the development agreement? 4.1.2, prior to the issuance of CO, concurrently with the closing of approved sale or transfer and assignment, owner shall provide the city with an executed agreement by the purchaser. Do we have a copy of this executed agreement?
We do not. We were informed in conversations, but not in the legal format that's outlined in the development agreement.
Okay, thank you. Are you aware of any other apartment buildings that are listed on preferred hotels or any other websites that rent on a nightly basis? I mean, is there anything comparable to this in your research that you found? In our city? In our city?
No.
Okay, thank you.
Is that it? Any other questions at this time? Staff? John, yeah.
Rachel, to your knowledge, does the appellant in this situation have any agreement or have any subsequent or any amendment to the development agreement in order to allow this portion of the middle parcel to be used as a hotel because of the fact that the east parcel is also a hotel?
No, they do not.
Thank you.
Commissioner Bass?
A lot of the information that we had in our packet refers to the short-term housing ordinance, the short-term rentals. But I didn't hear that in your presentation. Can you talk about that just a moment so that we're prepared to consider that argument as well?
Sure. So the short-term vacation rental ordinance requires that no unit be rented for less than 31 days to any transient individual. That's paraphrasing for sure. And so that ordinance was established in response to essentially, we'll just say Airbnb. So, one of the things that that tends to happen with zone text amendments is that we deal on a case-by-case basis with individual issues that come up. So we're essentially trying to alleviate issues with one specific kind of problem in the city. In this case, all of a sudden, Airbnb, blew up and people started renting their units on a short-term basis. One night here, one night there, a couple nights, that sort of thing. So the city staff, when they established that ordinance, meant to address that specific issue of rentals less than 31 days. You could connect that because we don't allow rentals for less than 31 days, that automatically allows all rentals of more than 31 days, but that's not necessarily the case. The goal of that ordinance was to alleviate the short-term, day-to-day rental of units. And so it didn't address this specific issue. And I think part of the problem with how kind of land use works now and kind of and it's a spillover to the tech industry even, is that, everything is new and uncharted territory at this point. So, this type of thing, having a high-end extended stay hotel was not something that we ever anticipated. The same way that the city didn't anticipate Airbnb suddenly taking people's ability to rent out their bedroom, once in a while as kind of a major problem in the city. So when that was established, it was really to address that one specific issue, but unfortunately wasn't a catch-all for every type of rental in the city.
Thank you, that was helpful. Any other questions, John?
I'm sorry, I had one more.
Go ahead.
I'm sorry, go ahead.
John, did you want to have a question?
No, I already.
You did, okay. Go ahead, thank you.
Could you just please clarify a little bit more? This building was given its C of O in January of 2017. So why has the affordable housing not been rented? I mean, I hear that there's been negotiations and discussions, but it's been 14, 15 months?
It's an interesting issue with the affordable housing because one of the conditions of approval is that you have these 17 units in the building and that they be rented to tenants that meet certain income requirements and they pay commensurate with that income requirement. In this case, the building received a certificate of occupancy without being actually occupied, and then exchanged hands. So as the city is trying to catch up with a lot of those things, often enough buildings will remain completely vacant as we start to kind of work on the process of occupying those affordable units. We tend to want those units occupied first before anyone else is in the building. So the city started working with now the new property owner and manager to start to try to get those occupied. And like I said, the East Tower, all those units have now been occupied, and we are now working towards the other one. This is probably the most kind of lengthy example, but these things do tend to take some time as both the city and the property managers and owners start selecting people from the list to occupy.
But to be clear, you stated that the applicant is already renting rooms to the public and has been for a number of months already, but the affordable housing is still vacant.
That's correct.
Thank you.
All of the units in the West Tower, affordable units, are vacant?
That's
all
correct.
Of them?
All of them.
Are there any other questions?
Well, one more.
Okay, John?
To your knowledge, has there been any discussion between the appellant and the city with respect to if, in fact, there is a meeting of the minds and there is some kind of resolution of this issue, any additional benefit to the city because of these changes in the development agreement and the entitlement?
Not to my knowledge. I mean, certainly that could be a conversation to have.
But the city has not had a conversation like that with the appellant, the property owner.
I mean, the city had a number of meetings with the appellants where that may have been on the table, but it was never something that had gone further than early conversations, to my understanding. I don't know how far those conversations went.
This seems to be the situation, in my opinion, and I would like to have yours too, that speculatively, in the long run, this has no place to end up in a court. That if somebody doesn't, one party or the other doesn't like what happens here, it gets appealed to the council,
if the same result or even a different result, there's going to be one party who's not going to be happy. So from there, you go to a court. Is that right?
That's certainly a possibility, yes.
So,
It's-
related to this, Lauren, what kind of precedent would we be setting should this body and council, if it goes to council, vote to grant the appeal and allow extended stay? What kind of precedent would we be setting with our other apartment buildings in the city? What would prevent the building right next door to my house from saying, okay, we're going to become an extended stay hotel in our apartment units? Since it's okay here, why isn't it okay 5 blocks away?
I think that's a larger policy conversation as to whether this use is appropriate in the city. As Rachel pointed out, we haven't seen this before. So we're here tonight to determine how to deal with it in our existing code. If the policy direction was to accept this type of use, we'd probably have to change our code to understand what this use is and whether appropriate development standards are required for it. I think it would be a longer-term conversation than just this interpretation.
Sure, but we would be setting a precedent that
Well,
said this is an acceptable use.
A zoning code interpretation is an interpretation of a zoning code that can be applied uniformly to other businesses. This one's unique because it has to do with a development agreement, and so it's a little bit more specific, but it would require a bigger policy conversation in the end.
Isn't it also different and separable from the rest of the city or the bulk of the rest of the city because it's part of the Sunset Specific Plan?
Yes, there's certainly specific factors to this issue that relate
So in
almost
other words,
entirely to 8500
the
Sunset.
effect of the possible precedent doesn't affect the really big bulk of the city one way or the other, since the SSP is a distinct geographic area.
Yes, but you're also trying to define what long-term means, and long-term is something that's not defined in our code at the moment.
Right, but that's a policy with respect to housing.
I-
Here you have a distinct geographical separation between, what percent? 92% of the city and this particular geographical location.
And there's multiple questions that are asked in the interpretation, so.
I had a question.
Go ahead.
Back to the affordable units for a second. So I get that it's taking longer than usual with this project, but I don't understand the reason. Is it because the city hasn't selected the tenants, the current landlord hasn't accepted the tenants? Why is it taking longer in this scenario?
My understanding from the housing manager was that they worked to lease up all the units in that east tower and are now working on the west tower. And I honestly can't speak to who is holding it up more.
Do we know when the east tower was fully leased as far as the affordable housing?
Since the last meeting, so within the past month, it's been fully leased up. And just in terms of the affordable units, I can't
Understood.
speak to the market rate unit.
At this time, do the East Tower and the West Tower have the same owners?
My understanding is yes, that they do.
And the hotel, which was part of the whole package, which is now the Jeremy, was intended to be the hotel. The rest was intended, as we understand it through the development agreement, to be residential housing. Is that correct?
That's correct. And you have a letter from the manager of the Jeremy in your packet as well.
Thank you. So do we have any more questions of staff at this point? And we'll all have an opportunity later if we need to address staff on it. So I'm going to invite whoever's going to excuse
Could
me?
we just do the ex parte disclosures before
Oh,
we start
yes,
the public hearing?
yes, thank you. Go ahead, let's go down the row.
I had a meeting with the applicant's representative to discuss matters that were in the staff report.
I had a phone call with the applicant's representative to discuss matters that are contained in the staff report.
I had a meeting with the applicant's representative, and we discussed what was contained in the staff report.
And I also met with the appellant's representative on issues that were covered in the staff report.
I had 2 meetings with the representative of the appellant, and as everybody else has said, it was items that are discussed in the staff report and the whole general issue.
I met with the applicant's representative, discussed items that are contained in the staff report. Additionally, I visited the website and used their reservation system.
I had a meeting with the applicant's representative to go over items in the staff report, and in that meeting, I also learned that they were thinking of moving all the low-income housing units to the east building.
Okay.
I'm
So-
sorry, can staff speak to that?
I know that there was a request at a certain point from the appellants to move all the units, and staff has not made any changes to our affordable housing agreement and does not anticipate doing so, and is trying to move forward with leasing the units in the West Tower.
And that would require an amendment to the development agreement.
It actually does not. The affordable housing agreement is something that's administratively signed in the city of West Hollywood, so it would not necessarily require a council approval. That being said, movement of all of those units to the East Tower, I think is very telling, honestly, of how they want to operate this building. And getting those units out of there tells you exactly what type of property they want to run. If that's what they're telling you, that certainly has not been the conversation as of recent times.
It's another piece of information that we can consider.
Is that perhaps what is causing the delay in filling these affordable housing units?
Certainly the lack of interest from the operators to occupy those units is likely something that, and to relocate them to the other building is probably what is helping to hold this up.
Is there any information whether there would even be another collection of units available in that other building? I heard it was already all leased, the east building.
In the affordable units are all leased. Perhaps the appellants can speak to the market units, which I believe are still available.
Okay.
Some of which are.
All right, thank you. We'll address it with the applicant.
Do you have any information or impression as to what percentage of the market units in the east building are rented?
I can't speak to that.
Okay. So then I'm going to invite whoever's going to speak. I guess when you come here, we've agreed that we're going to allow 20 minutes for your initial presentation. There will also be an rebuttal period, which is generally 5 minutes, and we'll leave it at that. Would you please, as you approach, state your name, city of residence, and your relationship to the project as it exists? Thank
Good
you.
evening. Can you hear me okay?
Yeah, I can. I don't know, everybody out there? Yeah.
I'm Jonathan Moore, Montclair, New Jersey, and I'm speaking here on behalf of the ownership group. So
I think, would you please...
You need to speak up a little bit more.
The microphone and speak louder.
Okay.
Your voice
Is that better?
fading out, yeah.
Yeah, sorry. Didn't know
what
to
is your
speak softly.
position? Are you an attorney or?
No, so my role, I work for a company called Brookfield, which is the majority owner of 8500 Sunset. My role at Brookfield is, my title is Managing Director, and I manage the investments of our apartment business. So let me give you just a real brief introduction in terms of who Brookfield is, and then I'll tell you real briefly about 8500 before I turn it over to my colleagues. So for those that don't know, Brookfield is one of the largest real estate owners in the world. We have a presence not only here in the U.S., but globally. We're long-term investors. We've been in business more than 100 years. We own all kinds of real estate, including a tremendous presence downtown in DTLA. We're the largest office owner in the city of Los Angeles. And we have just a vast number of apartment buildings as well in and around the LA area and the rest of the country. And that's what I do on behalf of Brookfield. Brookfield, additionally, aside from its real estate business, is very large in infrastructure and renewable power investing. And we do that in large part through what's known as PPP, public-private partnerships, with lots of cities globally around the world in partnership with them. Last thing I would note about Brookfield is the company, which I've been a part of for the last 8 years, is extremely community-oriented in all that we do. You'll see that in lots of manifestations. You go on artsbrookfield.com. We're the largest producer of cultural and arts and entertainment events at and in around the properties that we own around the globe as a community benefit. As it pertains to 8500, we acquired the property because we thought it would be an incredible use to do furnished service departments there, and that was the initial strategy of it. And just like every other acquisition that we've done, and we're involved in thousands of transactions every year, the rigor by which we pursue our due diligence is tremendous. We take what we do extremely seriously, not only on a business, but on a legal basis. We're great, in my humble opinion, community citizens. I mentioned Arts Brookfield. Our reputation is that, not only here in the U.S., Southern California, but around the world. And we're also great corporate citizens. If you look at our website and what we do, and you ask people around, I think our reputation precedes itself. And then the last thing I would note is we find the property to be very special. It's quite unique. We think the city of West Hollywood, while this would be Brookfield's first property in West Hollywood, though we're, as I mentioned, a tremendous owner of real estate in and around the Los Angeles area, is a really unique and special city. It's special, it's different, it's unique, and we want to be a part of it. We do that in everything that we endeavor to do and the real estate that we buy. So with that, I'll conclude, and I appreciate your time, the grant of additional time, and thanks for your consideration this evening.
Excuse me, we're going to ask you a question. I think we may have.
And I think if we ask him
Stop the
questions, you might
clock while
deduct
we're
it
asking
from the
questions,
time.
please.
Your last name is Work?
My last name is Moore, M-O-O-R-E. Yeah.
I didn't hear that, sorry.
That's okay.
In your due diligence process, did you or anyone working with you as a peer or a supervisor read the development agreement?
Yes.
Did you or anybody working with you as a peer or a supervisor or superior have any discussions as to the uses with members of the city staff at any level?
We didn't prior to closing the transaction, which is typical, not always, but fairly typical in transactions where a seller...
You answered my question. The answer is no. Is that... Now, the next question, which again is a yes or no answer, is that your standard procedure that you do not discuss with the city anything about the items you read in the development agreement?
We don't have a standard procedure. It's transaction by transaction, depending on the circumstance.
Okay.
However, you did know that the city of West Hollywood is pretty unique, and we have certain values that are expressed in our general plan and so forth that might cause some issues for your plan.
Commissioner, the only thing I would note where I was going just briefly before was in this particular transaction, this circumstance, as is often the case, sellers don't want, the prior owner does not want the buyer of the property to actually go in and talk to the city, so we abided by that here.
To your knowledge, for yourself or anybody working with you in the due diligence process, was there anything that raised any red flags or questions?
No, there wasn't.
So If I can
Yes,
chime in.
go
So
ahead.
you're totally, I just want to make sure I understand this. So for a 9-figure purchase of a building in West Hollywood, or in any city, where there might be an inkling that the use might not be supported, you guys were okay with not contacting the city? I just want to make sure I get this right.
Yeah.
I'm happy to address.
Yeah, please, thank you. Because just,
Yeah.
I mean, if this was like a $2 million purchase and it's like, we'll wing it.
We
For
yeah.
what is purported to be, I think, somewhere near $300 million, there was no interest in figuring out whether or not this was okay?
If I might take over
Please.
on that.
Are you going to be the next speaker?
I am, and I'm going to be the last speaker for purposes of the 8500 Sunset
Okay,
Project.
however, before you address that, and we'll hold that question, I think we had another commissioner want a question of this particular.
Well, I want an answer to my question.
That's good, but he's going to answer it, and he would like to ask a question
Please,
of this
please, please, please,
speaker.
please.
So we'll get back to it. Thank you.
Did you not inquire or know that in February 21st, 2017, the city of West Hollywood banned corporate housing before you purchased the property?
Not to my knowledge.
Because it was public. There was nothing secret about that, so, but you didn't know.
Okay, thank you. Thank you very much.
Thanks.
The
Thank you.
next gentleman that wants to come up and deal with the question,
Yes.
still standing.
First of all, my name is Eric George, and I'm a lawyer. I represent 8500 Sunset, and it has been an honor to be here in front of the Planning Commission. I really appreciate the Commission's time, and I welcome any questions.
May we have your city of residence, please?
Sure. My law firm is located at 2121 Avenue of the Stars, Suite 2800 in Los Angeles. So in
Not so
Central.
far away.
No, stone's throw away.
But your city of residence?
Personally, I'm in Beverly Hills, also a stone's throw away from where we are right now. So I just want to say, and I'm going to dive right into answering your question, but I have found in the brief time that I've represented 8500 Sunset, truly, I say this, normally I'd be in court and I'd say this as an officer of the court. I have found a client that has scrupulously followed to the letter and the number the ordinance. Scrupulously. And that gets to the question that I now want to answer. No matter what the size of a transaction would be, anybody would want to exercise the greatest amount of due diligence and make sure that they're really totally in compliance. And what I plan on doing in the next several minutes is going through explaining why, if you put yourself in my shoes or my client's shoes, you would say, to use your words, there is no inkling of any problem with the ordinance. And the only reason why that's so is because none of the categories that we have now been told applies. We're not in a situation where there's
Can you
even...
keep your remarks
can you
to
start the
answer
clock?
his question,
Thank you.
please? Because we're not...
Just to reiterate,
The
yeah.
clock's not running, and we want you just to address his question.
Certainly.
So just to reiterate my question, I find it hard to believe that Corman and Brookfield would spend hundreds of millions of dollars purchasing a building, and for a transaction that's sub $5 million, I'd say, and if they weren't allowed to talk to the city, I'd get it. But for an almost $300 million transaction to not confirm that, hey, this is what we're going to do, is it okay? Either it's a big omission or error, or it was planned. So what I'm just curious, as I just want to understand what the thought process was and why they didn't reach out to the city, and just clarify, please.
Sure, but Commissioner, I really respectfully disagree with that premise, because if there was a situation, if there was any ambiguity, you would want to do precisely what you're saying.
Correct.
I am going to walk through in my presentation, for which comes off the clock, precisely why, if you were in our shoes, you would say there is no ambiguity. I understand the deal, and this is a deal I'm entirely comfortable with. So,
And I'm telling you that based on my read of the facts and what Commissioner Cavallero just mentioned a moment ago, that there might be enough ambiguity, especially for a purchase of that size, even if there's the smallest inkling to check. That's all I'm saying. So,
Indulge me, because you haven't heard me yet.
okay, so why don't we get the clock
May
going?
I follow up on that question?
Certainly.
Are you the person that read the development agreement and the related documents for this transaction for your client?
No,
So you just
So
come on,
you're-
you just came on board recently, right?
I did. But to be clear, in response to that question, I have read it. I've read it extremely carefully. I've read the ordinance
But after the fact,
after the fact. That's correct.
after the sale was completed?
Correct.
So you don't have any culpability with respect to your clients?
No, but sir, I am telling you.
I haven't finished.
Yes.
You do not have the responsibility for having made the report to your client that this is perfectly okay, you have nothing to worry about, there is not going to be any pushback with respect to our intended use.
No, Commissioner, I did not, but I have to elaborate. I easily could and would have had I been in that
But you didn't.
situation.
But
I
you
did not.
The burden doesn't fall on your shoulders one way
No.
or the other. Thank you.
Okay.
No.
So are you going to be the next speaker?
I am.
Okay.
Would you favor us with the identification of the who or the them that did read it and would have had the responsibility to identify a red flag?
So as I may be doing a couple times, I'm going to look behind me because I want to make sure that every commissioner's question is answered perfectly, and that's not something I can do on my own.
Honorable Commissioners, Bill Delvac of Armbruster Goldsmith and Delvac. The owners.
City of Residence.
Are you going to be a speaker?
I was trying to answer the question he asked who read the development agreement.
Are you?
I'm
okay
pleased to
with
be a speaker. We only have
I don't
20
care who
minutes. We're trying
answers
to be respectful of
Okay.
the Commission's time.
that? So you're the one that read it? Is that
I
correct?
did read the development agreement. In
Prior
fact-
to the consummation of the sale?
Yes. Yeah. In fact, 2 different law firms read it at great length, and I didn't add up all the fees, but there were many, many dollars.
And you saw no red flags or
I'm sorry,
items?
can't you, sir?
You saw no red flags or items for discussion?
Actually, I find this really to be curious and ironic. The development agreement protects this project. It doesn't harm this project. The corporate housing ban was well after the development agreement, and we're not corporate housing anyway. We're not leasing to corporations. The corporate housing ban is irrelevant to this discussion.
No, but going outside the 4 corners of this agreement, which you guys have done a very good job of staying inside.
apologize, I'm very
Sorry, it's okay. Going outside of the 4 corners of this agreement, which you have done a very good job of staying inside of, did you guys happen to do a Google search to find out about what the political temperature about corporate housing might be in this city? And is that possibly might be an issue?
Well, it's interesting. The corporate housing ban.
Aside from, sorry.
No, but the corporate housing ban staff report states that the city was aware of properties from 1 to 6 months. We read the short-term ban. We know what the short-term rental is. The city's website tells you, us, and everyone that a dwelling unit must be rented for more than 31 days. The development agreement is about dwelling units. If you find, honorable commissioners, that we're a dwelling unit, there's no problem about the development agreement. If you find that we're not a dwelling unit, which we respectfully submit we are, then of course the approval wasn't about that. So I really find this whole recital about the development agreement to be curious. I don't think it helps the city, and frankly, it's irrelevant if we're a dwelling unit. So yes, sir, I did read it.
And it was
again,
your
what is your
responsibility to convey your opinion to the corporation that is involved in the purchase?
I'm not sure I understand the question, but what attorneys talk to clients about, at least before last week, was privileged.
And what is your city of residence?
I live in the city of Los Angeles, and my office is in the city of Los Angeles.
Thank you.
Thank you.
He lives in Beverly Hills and his office is in Century City.
No, not this one.
Oh, that's the other one. They're blending together.
The new one. Thank you.
Unless he's moved in with me, I don't think that's the case.
We are in West
It
Hollywood.
wouldn't be unusual here.
No, I welcome it. I'd asked, but. So
Are you going to start your presentation?
I am
You're part
going
of the
to,
group.
yes.
Thank you very much.
You
And
have
Okay.
16
we're gonna
minutes, 33 seconds on the clock.
Okay, thank you very much. That means the watch comes off and I pay attention.
Let him have his name and his city residence outside of that time.
Yeah.
So
They already did that.
I do want to first start with a couple of the questions that were asked. And Commissioner Altshuler, you asked the question, were there any communications about, gee, what might happen so as to avoid a contentious matter? And there have been some preliminary conversations, but more importantly, we are ready, willing, able, open to doing so. And I want to be crystal clear on the record that we are. And with respect to Ms. Hooper-Gardner, the question about the precedent that might be set. I believe that the precedent that would be set based on what I'm going to say really is one that simply says the ordinance means precisely what it says about the more than 30 days. But more than that, if there were any concern about the precedent, we could have a site-specific ruling that eliminates any concern about precedential value. So I am going to really skip through quickly on some pictures that I wanted to show because I don't think that's the best use of my time. But suffice it to say, I had pictures that I wanted to show because to me, they indicate something that I'm going to come back to. This is not a hotel by any way that we look at it. So what is it? It is a, and I have this on the screen, of course, it is a long-term multifamily rental project, and it is not only is it not a hotel, it's not corporate housing. In response to the Commissioner's question about corporate housing, it's not transitional housing either. Where do we come up with this? Really from a straightforward reading of the ordinance, of the city code. So, unfortunately, and I think this is, we're very clear about this, Ms. Diamond said, I was listening as carefully as I could, that the zoning ordinance interpretation basically said two things. We are a hotel, and units are not rented on a long-term basis. And it is my job to explain to you, commissioners, that's just not accurate, and it's not fair because we went into this deal with an understanding that the ordinance would be interpreted for what it says, not what one and now possibly two interpretations would need to say that it says that it doesn't say. So to move forward, let's look at the definition under the code of a hotel, okay? A facility with guest rooms or suites, provided with or without meals or kitchen facilities, rented to the general public for overnight or other temporary lodging, and an important word here, the adjective typically, less than 30 days. What does typically mean? And I'm going to be a little daft here, and I'm going to read from a dictionary, okay? West Hollywood's ordinance does not define it, but the Oxford Dictionary says typically is in most cases or usually. It also says in a way that is characteristic of a particular person or a thing. And ladies and gentlemen, 8500 Sunset cannot be a hotel under the code since it leases only for periods in excess of 30 days. It never permits stays of fewer than 31 days. So to go to the language of the ordinance, because 8500 Sunset cannot be said to typically do that which it never does, it's not a hotel under the ordinance. I can't be more simple, plain, and clear. I don't care how somebody tries to interpret these words. They mean what they say. Under the ordinance, we're not a hotel. Let me go further. Apart from just the reading underneath the ordinance, we had retained a gentleman, Bruce Bolton. He's the managing director of CBRE Hotels, and he's one of the nation's experts in hotels and hospitality. And this is, I hate overused metaphors, but let's look at this from the standpoint of the, if it walks like a duck, it quacks like a duck, it is a duck. So his resume is really an impeccable one. It's before you. I'm not going to repeat
each of these points other than to say that he has the academic credentials, he has the career credentials, he has taught about these topics, he's been a consultant, including to the city of Los Angeles, represented the types of governmental entities one would want. And what does he say about this project? He says it's not a hotel. The minimum stay at 8500 Sunset is 10 times the median stay at a hotel. Unlike hotels, 8500 Sunset literally requires a rental contract that grants a real estate interest in the property. As far as the size, on average, the apartments are over 1,000 square feet. Hotel rooms average 350. And unlike most hotels, in 8500, each room has a kitchen, a washer, dryer. Contrary, by the way, to one of the slides that was put up by Ms. Diamond, there is no room service. It's just factually erroneous. And as far as maid service, there's no daily maid service. It's actually done once a week. So from these facts, just a straightforward reading of the ordinance and what I would call custom and practice in the industry, we are not a hotel. Nor are we corporate housing. And I could read it. It's before the commissioners. I don't want to belabor the point, but there's a very clear corporate housing ordinance section, 19.90.020. Why doesn't it apply? First of all, the ordinance is wholly inapplicable. It was enacted a dozen years after the development agreement at issue, which established 8500 Sunset's rights. But even, let's just assume for the sake of argument that it did apply. It does, 8500 does not lease to business entities. It leases only to individuals. We just don't fall within that code section. Similarly, 8500 Sunset is not transitional housing. Again, there is the language of the ordinance before us. I'm not going to read it. I'm just going to say, again, the ordinance was enacted more than a decade after the development agreement was signed. It's simply inapplicable. And in any event, 8500 Sunset is not transitional housing, nor does it provide supportive services for the homeless. Same type of analysis. I won't go through it. For emergency shelter, it just doesn't apply. Why have I even raised this? Because in the report that interprets the ordinance, each of these particular parts of the ordinance was looked at to come up with the interpretation, but they're wholly inapplicable. So what is left? So none of these options that we've looked at applies. The sole remaining option is a dwelling unit. It's exactly where we fit. A dwelling unit is defined as a room or group of internally connected rooms having sleeping, cooking, eating, and sanitation facilities, but not more than one kitchen, which constitute an independent housekeeping unit occupied by or intended for one household on a long-term basis. I will get to long-term basis. That is what we are. 8500 Sunset has literally each of these attributes. Now, according to the city code, 8500's units are leased only long-term. Why do I say that? Because the city code also says short-term rentals are those for rent for 30 consecutive calendar days or less. And I know I sound like a broken record. We never do that. Ever. We are not short-term, and nor is there any mid-term. It's short-term or long-term. We are longer than short-term, 31 days or more. And to this point, too, let's look at how the West Hollywood Municipal Code is interpreted by the city itself. Let's see what the city itself says on its website today. I'd invite you to take a look with me at what the public sees. So you have, the language is too small, I think, in font, but let me just walk us through this, if I might, okay? And needless to say, this website is not casual, off-the-cuff advice. Let's look at how the city characterizes this. In bold, what you need to know. And this is, of course, about short-term rentals in the city of West Hollywood. And then in bold, what this law means for you. And am I at risk for eviction if I advertise a short-term rental? What do we know? Well, the city's website makes crystal clear. And it's the same website we'd be looking at if we all went online right now. All rentals must be for 31 days or more. It's precisely what we're doing. In addition, the city's February 6, 2017 staff report acknowledges leases of 1 month to 6 months, but less than 1 year, are acceptable uses of dwelling units. Doesn't this all come back to the question of, wouldn't you not want to have any ambiguity if you went ahead with this deal? I am telling you, there is no ambiguity. We fit squarely within the ordinance. There is no remotely colorable argument to the contrary. And my fear is that if the city is taking the position that it needs to have an interpretation of what long-term means, and that interpretation is it's got to be a year, it's just not right. The code could have said that. The code could have suggested it. It didn't do it. It is not spoken to at all. And it's one thing for this city to enforce an ordinance. It's another thing for the city to rewrite one. We don't do that. We can't do that. When I heard the words from Ms. Diamond, if the Planning Commission votes to affirm the interpretation, then we're going to go back and, quote, we would return to further clarify. Hello? We don't do that unless there's truly an ambiguity. There is nothing here that says anything other than what we know. That if we're renting for 31 days or more, that's long-term and it's okay. So, to state the obvious, the city cannot create a new law without notice. The city cannot apply a new law retroactively, certainly not in violation of a contract that it entered into a dozen years ago, and it certainly can't do so for one building. Let's see what other people are doing. This is the common practice in the city. And we made a very easy decision that we were not going to come here and identify anybody who might be deemed an offender, according to the new interpretation. But guess what? They are legion. That's not the position we want to be in. We do want to be in a position where we're all treated the same, okay? It is a common practice in the city, as shown by advertisements instantly accessible to the city and everybody else, that what we're doing is entirely legitimate, appropriate. Supplies not, I'm not just talking about a 1 or 2 unit place in a larger building. I'm talking about large, entire new buildings and apartments everywhere, okay? Let's look. Here's one, 31-day rentals permissible. In West Hollywood, you can choose 1 month, 2 months, 3 months, 4 months, 5 months, 6 months. Let me go to the next one. Here's a substantial building. I put in a red box here where it says 2 months. Here's another one, a very substantial building. Lease length, 3 months. Another one, 1 month. Another one, 2 months. You get my point, and it really becomes a matter of due process. The law, at its best, is the most important thing we have because it applies equally. And we're not doing that here if we have this interpretation. And by the way, I should say, goes without saying, all the slides I just showed, these people are not doing things impermissible. They're reading the law. They're not exploiting any ambiguity. They're doing what the code says they can do. They're not being impermissible. They're not being unlawful. Nor has the city, to the best of my knowledge, I'll represent to the commission, ever taken any code compliance or other enforcement action against any of them. Again, they're not doing anything wrong. Some of these landlords, in fact, rent for fewer than 31 days. But in any event, they all rent for less than a year. So to Ms. Hoopengarner's question, it would be quite a devastating precedent for many people who are lawfully abiding by the code. 8,500 sunset leases only for more than 30 consecutive days. There were some websites that were shown. They are not ours. They're not authorized. I am stating as a matter of fact, putting all of my reputation on it. We do not rent for fewer than 31 days. And I have slides here to prove it that will be part of the record, of course. I want to make sure I'm not going to run out of time, so I'm just going to speed up a little bit. Suffice it to say that I just want to emphasize to the commission that, again, another difference between a hotel and an 8,500. Prospective furnished unit residents at 8,500 have got to provide certain information. They've got to, okay, well, I'm going to read it. They've got to go through credit.
Your time is up, I'm sorry.
Okay.
Maybe you'll get an opportunity on a question to bring it up, but we'll see.
I do have a question, if I may.
Commissioner Bass.
Two questions for you. You mentioned that maid service isn't available, but when I made my reservation, which I've subsequently canceled because I don't need to stay there, I have an apartment of my own. But when I made my reservation, it told me that additional housekeeping is available beyond the one week, and I recognize that any one of us could pay to have our house cleaned every single day if we chose to, but I don't find that to be accurate. But one of the things that stood out to me in the reservation is, as I'm reading here, housekeeping service once per week for stays of 7 nights or more. So the actual reservation says if I stay there at least 7 nights, although this website only allowed me to rent for 33 days at the minimum for the time I was looking, it does give me on this reservation, it does mention a 7-day stay. So I'm wondering if you could speak to why the reservation would tell me 7 days if that's not an option.
Sure. So what happens is there is uniformity within the website for the many AKA properties. And some of those in other areas may be different. But what it will do is it will direct you specifically by link to 8,500 Sunset, which does not permit anything less than 31 days.
Okay, so this is just standard language for the brand?
Yes.
Okay. The next question I had for you, you mentioned that the corporate housing, the transitional housing, and the emergency shelter language should not apply because they were all adopted after the development agreement. Did I understand that correctly?
Yeah, that's correct.
Your
Yes.
colleague is shaking his head no behind you, so if you want to.
They don't apply on their face by the terms of the
Well, that too. Yeah, I try to go through both, but
I didn't hear his answer, though.
Honorable Commissioners, Bill Delvac again on behalf of the owner. Those provisions are simply not applicable to the project. We're not emergency shelter, we're not transitional housing, we're not those other things. And I could get out and look, I don't know the dates of the enactment of all of them. What I know is they're not relevant, and they're not in any way applicable to the project.
Okay.
In other
And
words,
I was
your website is generic and not in any way site-specific?
No, I want to be clear on that. There is a generic one, but by link, it tells you specifically, it refers you to this specific site. I just want to make sure that I've answered the Commissioner's question.
You mean if somebody's looking up AKA, they have a generic thing, and then it takes you directly to this site on Sunset Boulevard? Is that what you're saying?
That's correct. If you
And
hit
that
link.
the way you're managing the Sunset building, the project, is different than your general AKA policies? Is that,
There are
is that what you're
different-
telling us?
There are differences between some of the properties, and the link that we have to West Hollywood, again, scrupulously adheres to the ordinance.
So I just wanted, the reason I asked about those other three ordinances and whether they applied because, one, you're not any of those three things, and that they were adopted long after the development agreement by, if I understand correctly, is that you are referring quite a bit to the short-term housing, short-term vacation rentals ordinance, which I was here down there when the city council adopted that ordinance. And from their conversation, you are not that either, and it was also adopted 10 years after the development agreement. So I'm wondering why that ordinance, though you're neither one of those things, any of those things, why it applies but the other three do not.
It only applies in the sense of giving a sense of what the city believes would be short-term versus long-term.
And is there anything besides short and long? I'm reminded of Goldilocks, who said this one's too hot, this one's too cold, this one's just right. Is there something between long and short?
There's no perfectly temperatured porridge here.
Okay.
It is short or long.
I have a question.
I want to ask a question.
Appreciate the answer.
Thank you, Commissioner
I
Ross.
noticed that on some of the slides that you showed, you were talking about that you never permit stays of fewer than 31 days. And then another one says, we never rent for 30 days or less. So I recall that sometimes you may not rent for 31 days, but a lot of people pay for 31 days, but only intended to stay for 7 days or whatever. Is that, stays are different than rentals. Is that what you're trying to show? Because you're
No.
using both language.
No, then the fault is with me. I'm not trying to draw any distinction there. To the extent that somebody would cut short a 31-day stay and say stay 7 days, it would be a violation of certainly the ordinance, and it would be prohibitively expensive for somebody to pay that amount of money and not be there the entire time. So I just want to make sure I'm following, because I don't see that happening.
People cancel, in other words, or they get called away. And another question I have is, would you rent to a corporation? A corporation is considered a person or an individual in a lot of situations. Are you just renting to families or individuals, or would you also rent to a corporation for 31 days or more?
I'm going to answer, and I'm going to quickly invite myself to be corrected. We rent to individuals and families.
Okay, thank you.
But if an LLC or corporation cuts a check on behalf of that individual, you accept it?
There is literally a contract, a real estate contract, again, unlike a hotel, that the individual has to sign, which makes them personally liable and gives very different types of rights than you would have if you go to a hotel, present a credit card, and check in.
So I have a question. Let's just say I book a 31-day stay. When do I pay for it?
Good question. Yeah, right, but how many?
In advance?
Oh, for sure in advance. I'm trying to get more specific.
Commissioner Agai, my reservation told me that 15 days charge would be charged 15 days in advance.
So wait,
And
could you clarify? I'm sorry.
That 15 days worth of the stay would be charged 15 days in advance of the,
advance.
that's what it,
15
I don't
days
mean
in-
to answer on their behalf, but that's
So,
what it told me.
So I want to
just wanna
understand, how is this room paid for? Well, I get a room for 31 days.
So I just wanted to make sure you have it. I wanted to get a specific answer. At least 2 days beforehand, the entire month has to be paid in advance.
What's the cancellation policy?
And are there any refunds?
The lease is for a stated term.
The lease is what? First,
Stated
I
term.
understand that I understand that the lease is for a stated term, but leases also have. I used to be an attorney, so
Dangerous.
technically still am. So, I mean, it has a termination clause, or I'm guessing, or it doesn't. So let's just say I pay for my 31 days and I walk away at day 15. Can I ask for my money back for the other 16 days, or did I forfeit it?
Are there any refunds allowed?
Refunds are not permitted.
Refunds are not permitted.
Correct.
But I just heard Mr. Bass, Commissioner Bass, say that he was told that 15 days is charged in advance, and you say 2 days prior taking tenancy, the whole thing is charged in advance. Now, he was told this by a human being.
No, I was told this in writing and in the.
Oh, in writing.
Is there
What am I
someone here that
doing, sir?
operates the, whatever you want to, whatever you guys are calling it, who can kind of give us like,
Somebody who
as
actually is
opposed,
at
as
the
opposed to
location?
like, don't, I have nothing against attorneys, but is there an operator here that can answer this? Can you please? Thank you.
I'm an attorney in remission, so don't hold it against me. My name is Rob Grossman. I work for the operator, for Brookfield's partner. I'm executive vice president and in-house counsel for Corman Communities. And let me just make one thing clear because everybody seems to be a little confused. We have generic branding involved, which is confusing because we operate in a lot of different jurisdictions with many different length of stay requirements. We adhere to every local jurisdiction in the fashion we are required to operate. We always abide by the law.
So you advertise to everybody, but.
We advertise to everybody, and if you want to rent a unit at West Hollywood, you go into it.
You advertise to everybody.
Correct.
And you make everybody happy by your advertising, but then you say, when it comes down to their getting to the front door or wherever it takes to consummate the deal, well, maybe we could do this, maybe we do
No,
that.
that's not at all right, respectfully, sir. It's what we do is.
But it's what we're hearing. It's what
Well,
it sounds like.
I would recommend and encourage you to look at our website and go to each property and see right there. So each property adheres.
The only one I can go to is the one that's,
Physically go to. On the website, you can go anywhere.
the only one I can physically go to is on Sunset.
So,
Or you can probably go to one we have in Beverly Hills.
Where?
In Beverly Hills.
Oh, yeah, I was there once. I was taking a tour there.
So let me just ask a question with regard to the maid service. So
Sure.
there's maid service one time a week as part of the rental?
There is
of the
maid
unit?
service once per week as part of your rental. If you want it more, you can pay it a la carte, exactly as Mr. Bass stated. Just like anybody who wants additional maid service, they want it twice a week, you pay for it extra.
Normally, when you rent an apartment, you have to secure your own or make a contract with somebody outside for maid service. It's not just there on the premises as part of
It's a
the...
feature we offer. And some people don't
That
want
would be
it.
more like a hotel, because they're not paying directly for the maid service.
Hotels have daily maid service, Mr. Chairman.
I think hotels automatically have daily, certainly the expectation of anybody
Sometimes.
staying at a hotel.
Now, because of economy, they're asking you not to have your sheets changed every day or hang up your towels or
Right.
whatever, so that doesn't really,
Things are definitely changing in how apartments operate and how hotels operate. I think you're finding that apartments
So,
offer a lot of services.
okay, go ahead.
Mr. Moore, you gave a number of examples in your presentation. George, sorry. A number of examples in your presentation of apartments offering 30, 60, 90-day lease terms. Were any of those apartments subject to a development agreement?
I don't know.
Were any of them furnished? Sorry.
Don't know.
Okay, because those two components would be significantly different.
Well, but I'm not sure I follow, because the fact is, any reading of the ordinance that results in an interpretation that there has to be a year-long stay to be deemed long-term would denigrate any type of difference based on whether it's furnished or not, or whether there's a development agreement.
But there are different restrictions in a development agreement than in...
This is an interpretation of the code.
Okay. I have a few more questions for you.
Our vice chair ask questions, and we'll go back to you. Thanks.
You can finish your questions, Lynn.
Oh, okay. Sorry, I saw your name first.
At any time since you've opened, have any of your own employees, staff, attorneys, et cetera, stayed in this facility at all?
No.
Okay, thank you. If an individual wishes for you to remove all of the provided furniture and move in their own furniture, what would happen?
I think that's something we would consider. I don't know that there's a set policy that would
You
dictate.
charge a fee for that?
I don't know.
Okay. What is the difference between a 24-hour residential service and a concierge?
Again, I apologize that I'm not on the ground and able to answer this question, but I want to make sure you have an answer to it.
I'm going to try to assist there. I think a concierge is an individual who one expects to see at a hotel be on a desk that says concierge. Concierge service is either something that can be done electronically or, frankly, in today's world, since we don't provide room service, we don't provide a lot of those normal hotel services. You can have food delivered by Grubhub, by Seamless. There are a lot of other ways to access services. I think that's the difference.
So but you have someone at a desk 24 hours per your stated website.
As most apartments do, and condominiums, yes.
And so
High-end
how would that
ones.
be different from the concierge that's at the desk at the hotel?
Because the concierge only does things like, in my experience at hotels, making reservations, recommending sites to see in a city for people who are staying for a day or two.
And the 24-hour guest service in your facility does?
24-hour person is more for security, frankly, and does just what a person in a higher-end apartment house or condominium does, who would sit at a front desk. No different, really.
Did you have a follow-up?
Yeah, I just didn't get clarity on the whole, because I heard something different about the payment schedule. I just wanted clarity on that. So can someone give me a definitive answer on when I pay, how I pay, and what the cancellation policy is?
Could you repeat that? I'm sorry.
When do I come in for a 31-day stay.
Right.
When do I pay? And what portion, if any, of my rental payment is refundable if I decide to vacate early?
None, in West Hollywood in particular, although we do have the same protocol for every 31-day stay facility in the country. If you do it online, as an example, which people seem to be talking about, you have to pay a month in advance, and then you are subject to a credit check, a background check, and there's at least a 48-hour delay. I certainly don't know any hotels that have a 2-day delay before you can walk in. Then you have to sign your lease. You have to accept your lease and sign your lease. Then you can move into your unit.
And if I walk out after the 3rd day, I forfeit the rest of the month?
Mr. Aga, it's no different than if you have a 2-year lease and you walk out after 6 months.
I'd be responsible for the remainder of my lease.
You're responsible for the remainder of your lease here, too, as I've told you
that's
several
what I'm
times.
asking.
I'm sorry if that wasn't clear.
Thank you.
But in mitigation, if you can find somebody to take your place, then then you solve that.
That's a
portion.
legal matter. If the,
Well,
if
but
the
you
if the
follow
tenant
those
pursues
do you follow
anything, yes,
those?
there's an obligation to mitigate, but
Can
that's
can I
really
ask you on
no
the
different.
affordable, I'm sorry, on the
Yes.
affordable units,
Sure.
how long are those leases?
Those leases are 1 year.
They're 1 year?
Yes, they
And
are.
they will be in the new building, in this other building that you haven't quite done?
I want to explain that whole situation. I don't know, Rachel, how familiar you are with it because you came in afterwards. We met with the individual from the city who was handling the affordable housing units. We said we'd love to get started on those units. And we were then told, I guess that individual retired and somebody else communicated to us, and before she retired, I guess we did make the request Ms. Diamond referred to, that we wanted to have all the affordable units in the unfurnished building so that people would feel no different. They wouldn't feel like a fish out of water if the rest of the units were furnished and their units were not. And we made a request for specific units to be used in the East Tower, which are all larger units, by the way, and we thought would be, more attractive. We were then told very specifically, we can't address those now until use issues are settled.
So are those units still available?
Yes, they are.
They are. And all of your affordable units are leased for at least a year?
Yes, that's correct.
And why is that? I mean, even if they were in this other building, they would be for a year?
They would be for a year, correct.
And why is that?
that's what the city, we have a very specific agreement on affordable housing that was part of, I don't know if it was entered into, I think it was entered into several years after the development agreement, but it requires 3-year leases.
I think it was part of the original development agreement.
I think it
the
was
affordable housing.
I think it was a separate agreement.
I think that.
But very close to it,
They were
yes.
supposed to be condos originally, but then there was an amendment to make them.
Okay, so by amendment, but definitely a subsequent agreement.
Having made a reservation, I'd like to just really quickly follow up with the question, with your answer to Mr. Guy's question. And that is, you said when you make a reservation that you're subject to a credit and background check. I made no agreement that for you guys to do either of those on me. When I clicked through, I read everything. I challenge you to tell me where I missed that. But I made no consent for you to do a background check for either one of those. And you mentioned a 48-hour delay. I had the reservation done within 5 minutes of
You've had the
starting
reservation.
clicking through.
The way it works is you have, and I don't know if, I don't know the actual mechanics of it.
Oh, and just one other, and that is that you said about you pay 30 days in advance, and the agreement here is that I would pay I'd pay half of it 15 days in advance. It makes no mention, but that's what's here in the reservation that you emailed me.
Did you get the actual lease? Did you get the actual
No,
lease?
it said that I had to return that within 3 days after arrival.
The actual lease, which would have eventually come, would have had requirement of full payment. And that's probably when your social security number would have been required and your consent.
Okay.
So they wouldn't, are you saying that they were going to give you the lease 3 days after your arrival?
They said I would need to return it within 3 days. It also said that I needed to, I read in one of your letters that there's no front desk, and I can't find it in here, but then it said that I could pick up the key at the front desk. So I had some of those same
I
questions.
think that's a matter of semantics. I think there's a front desk in any building you walk into.
I think this whole thing is
a
a matter of
hotel front
semantics.
desk has different connotations. I didn't hear that, sir. I'm sorry. Would you repeat it for my benefit?
This whole thing is a matter of semantics.
And
So,
isn't that where we're at?
Yes,
I have,
yes, and I'd like to answer that.
And
It's
reasonable
semantics.
minds can differ as to that kind of interpretation.
Madam
No,
Chair.
I'm going to,
We'll end up in litigation because I think whoever gets an opinion here that they don't like is going to appeal it. The same thing with the council, so I think there's no place to go other than to a courthouse, which is a shame because I think you have something very interesting to offer, and I think that our city should be amenable and should be interested in seeing if we can
See if you can work
get
it
some
out before you
additional
go there.
benefit to the city and proceed to use that benefit for the general good.
I appreciate that very much. As I started off saying, we're ready, willing, and able to sit down and try to do something like that. I think it makes sense. I think that this is an option that's incredibly interesting and unique, and that we like choice, and this kind of choice is a brilliant one for people to be able to have. As far as semantics, I do respectfully disagree with the chair. When I look at the ordinance, there's no ambiguity, truly.
And I disagree
We
that semantics would include the city policies, the city philosophy, which is certainly clear, and the city represents a residential philosophy that says we are here to provide housing for families on a permanent basis.
Absolutely.
That is something that is protectable in every time we go, is attempted to be protectable in every time we go to court, and we do go to court.
Yeah.
But I think this is a situation where we should try to avoid that.
Absolutely.
Thank you.
For the benefit of everybody.
Absolutely.
But I don't have the final say in that.
That's right, and
Thank
thank
you,
you very
Commissioner.
much. Thank you.
Thank you very much.
Wait a minute, Stacy wants to talk. I was wanting to move on to public comment, but.
Sure, I just have a question, the only question I've asked so far this evening, so thank you.
And I want you to answer.
I just want to understand, and you may not be able to answer this, but I want to understand why the Google and Yelp listings specifically have this particular property listed as a hotel. It's classified as a hotel, and if you own the listing, which I presume you do, or the owner does, why it would be classified as such. It's hard to contest, it's hard for me to understand kind of your argument that it's not a hotel if it's being advertised as such.
Totally understand. We are not advertising 8500 Sunset as a hotel. The things that we see on Google, Yahoo, Yelp, et cetera, that are inaccurate are obviously legion. I wish I could be more specific than that, other than just to tell you on behalf of the company, we are not advertising 8500 as a hotel ever.
Does that translate into the fact that you are not running it as a hotel ever?
Well, that's correct. We don't advertise it, and we are not a hotel.
Excuse me, but on your website, in multiple places, it refers to the words extended stay, from meticulous housekeeping and complimentary Wi-Fi to a dedicated doorman and 24/7 resident service team, AKA offers everything you need for your extended stay. It repeats extended stay. It's got high-speed Wi-Fi. That means business stays on track. I don't know of anybody who stays in an apartment building. It's your residence. You don't stay.
You live.
You live in an apartment building. You change your address. You vote. You register to vote. At the beginning of each public speaker's comments, we ask that the speaker state their name and their city of residence. Would anybody living in this building, staying in this building, be able to truthfully state that their city of residence is West Hollywood?
I love that question, because anytime I have a client, I try to figure out everything I can from their perspective. So I try to get a grip on the AKA brand and what it does. I visited the Beverly Hills one, I visited the one here. And what I came to learn, and I confess from the very beginning, when I first learned about it, I'm not sure I really got this, but here is the point that I've learned. There is a very interesting development with people who want to have choices and be able to live in places for less than a year, but still well over a month. And I don't know if that's because it's a matter of experimenting and seeing where somebody wants to live and giving something a try, or what. But I think that there is a sweet spot there that maybe people haven't addressed before. Maybe that's part of the strategy that's being implemented by AKA. But I do think that you can have an extended stay, and you can also refer to that, in other words, as a residence.
I will repeat, stay and hotel, you live in an apartment. I'm just having a hard time reconciling that concept.
I get it.
And how you are a resident who is going to vote in a city when you're not a resident.
Well, it may be that for voting, there are different types of duration that you have to prove, but I think for purposes of where somebody lives, maybe the language hasn't caught up with that for some people yet. The fact is, there is a population of people that will want to live somewhere less than a year. Why shouldn't we give them an opportunity to do it?
So, to move on, can you explain why the applicant has not complied with the development agreement in terms of the notification of the city?
So my understanding is, and I may need a little help here, but my understanding is this, that as you heard from Mr. Moore initially, this is not a general practice, but the contract prohibited any disclosure by the buyer to the city prior to the closing of the transaction. Fair enough. More than that, I believe that section 4.1.2 of the development agreement does not require what's being suggested, because the transfer happened after the delivery of the certificate of occupancy.
There was still a transfer of ownership,
Yes, there was.
and the city was not notified.
Honorable Commissioners, Bill Delvac again on behalf of the owner. Section 4.1.2 refers to a transfer before development. The certificate of occupancy was obtained. The provision after development says the owner shall give notice. I believe the development agreement clearly means the seller. It doesn't say that, but I think when you read the whole thing, if anyone was to have given the notice, it was the seller who should have. Who was the party to the development agreement?
Are you
after
not
all?
now the owner?
I'm sorry?
Are you not now the owner?
After the transfer, but not before. I believe that when you read this, that after transfer, after development, pardon me, that the owner that is to give notice is the seller. They're the party to the
I'll
It
leave
agreement.
doesn't
that.
say seller, though, it says owner.
It just says owner, so I'll leave that to the lawyers to discuss.
Yeah, that's another interpretation.
But there should have been notice, I believe.
Well, as Mr. Moore said,
See, the unfortunate thing here is that there was an opportunity for the new owner to have some conversations with the city and work a lot of this out before we lawyered up and we got to this point. And unfortunately, there's still an opportunity. I would hope that somehow or another you would try to work something out with this city so that it's a win-win situation for everybody.
So
before it gets to more and more litigation and more costs, both for our city and for your client.
Chair and other commissioners, because this has come up, in a 3-month period from the first letter from the city until September 21st, when the city said they were going to require an interpretation, we had extensive discussions about the nature of the operations. We had genuinely believed, I was in those meetings, we had genuinely believed that we were on track for reaching an agreement. We still believe that we're a dwelling unit, it's a valid property type. We would be shocked if the city now tells the real estate market and people who can't get into a 1-year lease that the city is closed for monthly rentals. I'd be shocked. That's what you're about to do here.
How far along are you in renting the, for those affordable housing in the other unit? I mean, is there something, anybody know what's going on there?
As I mentioned before, we made the request on the 9 units in the West Tower to relocate them to the East Tower, and we were told by, I believe it was Mr. Noonan, that for the time being, we should wait on those until all these matters were settled.
I have one last question for the operator. Or did he leave?
Yes, that's me.
Oh, I'm sorry.
Okay.
The electric bills. Who pays the electric bills?
We pay the electric bills. It's
And
included in your rent.
The
Gross
internet?
rent.
And the gas?
Yes.
So unlike most any
Cable?
apartment building I know,
It's gross rent, correct.
where we have sub-meters for a reason. So this is like a hotel
We may
where-
have some sub-meters that I'm not aware of, but because in some of our buildings we do, I'm not positive what we have. But typically, we offer services on a gross basis.
So.
Tenant pays for all of
Can
them.
staff speak to the sub-metering? Because it was my understanding that that's a requirement
I can
of all
answer.
new development.
I can answer that. Presently in West Hollywood, we have quite a few buildings that have 1 meter, and it's included in the rent, or in condominiums included in the HOA, because they were built with 1 meter.
Yeah, but I mean, this is a new build, is my point.
Yes.
And we have new rules about sub-metering, don't we? Can staff speak to this?
I honestly can't speak to their meter situation.
I've
recall.
never seen a requirement, actually, that there be individual unit meters. It's certainly desirable.
Some
but it isn't.
apartments, some buildings have that, but
Still-
many do not here in the
Right.
city.
But the internet, your cable bill,
Usually, those are paid by the
the
tenant.
individual in a normal tenancy, in a normal dwelling unit, correct?
Not exactly.
No?
There are lots of bulk rate arrangements with apartments where the rates are much, much cheaper if you bulk it.
And it's all grossed up?
And it's written by one check by whoever, and practically every condo has it.
Correct. That's correct.
Condos, yes, but this isn't a.
Some apartments
This
do.
is a rental apartment. Okay, thank you.
It's built into the rent, but it does exist.
I'm not a renter, so maybe,
I'm sorry you just sat down. You mentioned in response to my last question about me not receiving the lease, and that's probably why I didn't get the request for a credit check, and there wasn't a 48-hour delay. You folks included a copy of the lease that I suppose would have been what you were referring to. Granted, it's a bunch of pages and small type, but I'm not seeing any reference to that in the lease. So is there a different lease than the one you provided us that might?
That
have
is
some-
our lease. There may be an additional form, but I can,
Okay.
that you
I'm
have to
just-
sign. There is absolutely a separate authorization form.
For those things.
That I'm aware
Okay.
of.
So Adam, if you have it, there's a section in there about utilities, and there's check boxes that says the owner will pay the following utilities. So the question is, are those boxes checked?
We all have it in our packet. I can flip through here, but. I didn't mean to be short with my answer when I said that. I just don't know that I will find it very quickly. Utilities, none of the boxes are.
Right-hand column
none
of
Yeah,
page
none of them
one.
are. None of them are checked.
None of them are checked, okay.
Okay. Can we, at this point, move on? We can still ask questions before the public hearing is closed. So I'd like to move on so we can give some of our public an opportunity to address the commission. So going on. Chair, yes?
I request 3-minute intermission.
Yes, please.
3-minute intermission. Okay, thank you.
I would like to amend that and make it 5.
I'll just remind, excuse me, I'll just remind the commissioners that the public hearing is open, so not to
Yes,
speak
and that
about the
means
matter amongst
please do not,
yourselves.
any members of the public, address any of the commissioners on this.
We're good. I'm hoping I'm not being too aggressive. Not discussing the content, but just my demeanor. I just
Can I have all the commissioners back? And everybody in the audience, if you take your seats so we can continue, please. Have everybody in the audience please take your seats, and we're going to continue. We're moving on to the public speakers on this item. We're going to allow you 3 minutes, even though that we have over 20 people, because I want to give you an opportunity to address. If you don't need to take the whole time, I think everybody here would appreciate it, but you're certainly entitled to it. So let's start. First speaker is John DuPont. You like the fence? Well, wait a minute. What? Excuse me, there's only one person at the podium, so the rest of you just take your seats, please.
My business is in West Hollywood. I'm here tonight speaking for the entire hotel community and asking the Planning Commission to deny the appeal for 8500 Sunset. To allow hotel or short-term rental use is against the zoning ordinance, excuse me. As operators, we've all supported new hotels in this market and welcomed them. This just wasn't done to a hotel, and it should not be a hotel. If you open this door to short-term rentals, it'll never close. And I guarantee you'll have other apartment buildings up here asking for the same consideration. A change of use removes rental units from the market, and the operator should have no problem finding long-term tenants. It's a beautiful building. A lot of people want to live there on a long-term basis. Thank you.
Thank you. And the rest of you are other hotel owners that just came up to support you. Is that correct?
That's correct.
Thank you. Moving on, Genevieve Morrill, followed by Adam Kaufman.
Hi, Genevieve Morrill, President and CEO of the West Hollywood Chamber of Commerce. Good evening, Madam Chair and Commissioners. Decades ago, as you have as well, this project was before us, and we supported 2 towers, 1 condo, and 1 hotel. There's no need to belabor that point. I think you've done a very good job of exhausting the semantics on that. We believe that if this should have been approved as an extended stay project, the EIR, the traffic patterns, the parking, and other merits would have been considered differently. As Commissioner Cavalario pointed out, corporate rentals were banned last year. I also want to say that this isn't an isolated item that has ramifications with other businesses. Pally House, if you recall, came before you around that same time. And Pally House got a citation and got shut down for using their residential units for short extended stay. And this was exactly the same scenario. We respectfully respect AKA's business model. And we believe that this model would be appropriate if it were a project that had all of the thought leadership that had gone into the first project and had been evaluated and looked at with the EIR in mind and all of the other elements. So we respectfully, ask that you, deny the appeal and support the staff's recommendation. Thank you.
Next, Adam Kaufman, followed by Amanda Hyde.
Hi, Adam Kaufman.
Sorry, Adam. After you is Ellie Farmer. I'm sorry, I missed that.
All right, Adam Kaufman, Director of the West Knoll Condo Association and President of the West Hollywood North Neighborhood Association. I just have some points I just want to raise. That we all know that there's a California housing crisis, and major density bonuses are being given to developers in our neighborhood. I just read an article that said West Hollywood is the densest city in Southern California. So that's why you're up here, we have staff, we spend a tremendous amount of resources going through all this stuff. Despite like all the quibbling about definitions, this is basically converting long-term housing into short-term housing. And that's counter to the state mandate to boost our housing stock. I have a particular interest in this because there's a project that's going to be built across our street, 8555 Santa Monica Boulevard. They're getting tremendous density bonuses using everything available. It's apartment buildings, it's the same scenario, and if you approve the appeal here, I don't see what's going to stop this project from converting to similar short-term housing. In terms of due diligence, I heard from the lawyer that they have a total disregard for the development agreement. So then I ask you, why do you guys spend your time going through a development agreement process? What's the purpose? Why do we pay staff to go through the process? Why do we have to come here and talk about this if there's no substance to these development agreements? Why does this city invest so much in development agreements, time, money, staff, our time? And we all know that short-term housing has higher margin than long-term housing. This is a great business deal for them. And by the way, they're not even paying the transient occupancy tax. Are they required to follow the same compliance as the hotels? Is it fair competition with the hotels? And ultimately, are they poaching business from our hotels? Thank you very much.
Ellie Farmer, you're next, please. Sorry.
Good evening, Commissioners. My name is Al Farmer, and I'm speaking tonight on behalf of the 30,000 members of Unite Here Local 11, the hospitality workers union here in Southern California. So I don't want to retread a lot of what you have asked questions about and what other folks have said, but there is a definition of dwelling units in this city, and it is in relation to the one cited by the appellant here. 1948-60 states that dwelling units within the city are intended for long-term occupancy as reflected by the dwelling unit definition, and as such, no part of the dwelling unit in the project may be used as corporate housing. This is the corporate housing point that has been raised, and I think it's very important. This building is being operated clearly as a hotel. I think we've all agreed on this point, basically, now that it is very clearly being operated, marketed, and run as a hotel. It was not permitted for that. It is permitted as dwelling units, as apartments for people to live in, not stay in. They are marketed as suites. I can't remember the last time that I looked for an apartment and it was marketed to me as a suite to stay in. This development was given special consideration, density bonuses, all kinds of things in a long process with the city to be what it is today, and yet this applicant, this owner, has come in, made a very large purchase, as Commissioner Agai pointed out, hundreds of millions of dollars. It strains credulity to think that they didn't know what situation they were getting into. It seems like today they want to find a tiny, tiny, tiny reason to drive a massive truck of a loophole into this city. There's a housing crisis going on in Southern California and California generally. We all know this as well. This would be an elimination of housing units. that is not going to help that problem. It might be good for their bottom line. It might help them pay some of the cost of their multi-$100 million purchase, but the city's laws don't really care about what's best for their particular bottom line. Their brand is as an extended stay hotel, and they're operating an extended stay hotel. I also wonder, in hearing about this, if someone were to rent one of these units and they stayed for 2 months, but 40 days into that, there was a dispute. Let's say the heating unit broke in one of these suites, and the person who was staying there decided to not pay the full amount, which would be their right as a renter in California. What would they do in that case? Rental rights should attach. I'm not sure how they would deal with that. Thank you.
Thank you. Amanda Hyde, followed by Elise Eisenberg.
Good evening, commissioners. Hello, I am Amanda Smash Hyde, and I am a rent-stabilized renting resident and a small business owner in the city of West Hollywood. I am a proud advocate for the rights of renters. I have been thoroughly researching this situation. I have to tell you, I am floored by the absolutely blatant duplicitous behavior by this developer. The project has been in the pipeline for 20 years, and they wanted an event space, and then they needed parking allowance, and now housing. They have come before the city trying to decide the most lucrative vein for themselves, not once, not twice, but 3 times. It is not the city of West Hollywood's responsibility to give you the best return on your investment. Do your due diligence and stop wasting everyone's time for profit. Do not pitch to us that we are stopping you, and this has been a transgression of the city to stop progress, when if this is what you wanted from the onset, you could have conveyed it easily at some point over the last 20 years. You never said to the city that you wanted short-term or corporate. You said housing. Furthermore, you said rental housing, which our city and our state desperately need. So what the city and myself are reiterating to you is the definition of housing, because apparently some people don't know how to adhere to their agreements. You make our work fighting the housing crisis even more of a battle. So for that, shame on you. I see the ads for you doing a hotel on Instagram daily in my Instagram feed. In a study from the Los Angeles Alliance for a New Economy, they cite that short-term and corporate housing like this is a major culprit in our housing crisis. It destroys the rental market, and its largest victim, guess what it is? It's affordable housing. Our council recently outlawed short-term housing and rentals because West Hollywood cares about renters. I care about renters, and in our current economy, renting is the most common way people can afford a home, myself included. We are 78% of this city. I don't come to meeting after meeting fighting for housing to be built, to have this blatant bait and switch abuse of the system to happen. This is personal to me because housing is a fundamental basis of West Hollywood, and it's a freaking human right.
Elise Eisenberg, followed by Joyce Heftel.
Elise Eisenberg, City of West Hollywood. I'm here to support the hotel owners because the last thing we need is another hotel on the Strip. We've been complaining that you've doubled the number of hotel rooms on the Strip, and it's the last thing we need. We're destroying the Strip. We're destroying the economy there. I'm really disappointed that there's even a suggestion that we look for a compromise with them. It's basically saying, what bribe are you offering the city in order to make this work? You know, I mean, I can't believe that's even up for discussion. And worrying about going to court. Well, so what if they go to court? They have a development agreement. Everything that was done, the way this was entitled from the beginning, 20 years ago, as they said, everything has been thrown out. When Sim even wanted to build this property, the city they were just nickel and diming it. Well, if you don't do this for us, if you don't give away 350 parking spaces, we're not going to buy the project. If you don't give away the underground tunnel. We're not going to build it. Oh, we won't build it unless we don't have to build the balconies on this. Every little thing. This was supposed to be condos. Now it's rental housing. But it was always housing. A hotel was across the street. This has to stay housing. We can't have a hotel on every other block from Doheny all the way to Crescent Heights. There's nothing else new that has come on the Sunset Strip except the hotel. Not one other thing in the past 10 years or the next 10 years going forward. We just can't have that anymore. This has to stay the way it's going to be. And you can't be worried about losing a lawsuit. The city is in the right here. You know, you can't have that fear. And you can't be asking what bribes we're going to be getting in order for you to get your way. That's a non-starter. I can't even believe that's even up for discussion. Anyway, I am here to support the city's position on the appeal. Thank you.
Joyce Heftel, followed by Jonathan Freeman Anderson.
Joyce Heftel, Fountain View, closest, one of the closest residential to this project. And I'll tell you right now that we are experiencing what we never experienced before is thefts, with people coming into our hallway stealing our packages. Not till this. I have no proof, but bringing more people here who do not have a stake in this neighborhood is never a good thing. I was at I'm sorry, I'm talking loud, I'm so upset. I was at every meeting when this development agreement was formed. I know the conditions. We were so impacted because we're right behind the two hotels. Incidentally, it started out as an approval in 1999 as 4 office buildings. So it's just, and Jeff Seymour is sitting there and with them, and he knows what conditions were applied. So if they're saying they're ignorant of it, they got somebody sitting there that sat there for Apollo and CIM, who said precisely, we care about the neighborhood, we're not going away, is what I just heard from this group. They're here for money. Every time we come before you, because there's another development agreement, another development that's going to impact our lives for X amount of time, you say you have no choice because of the state mandate. They are pulling 190 dwelling units off the market that were anticipated, and that's not right. They're not paying the taxes. They're not adding to the neighborhood. This is 2.8 square miles. It's not the city of Los Angeles. It's a tiny neighborhood, and we are being exhausted. And if those 190 units aren't for homeowners to live in, for people to have their resident, there'll have to be another 190. Our green space is going, our infrastructure, our plumbing. This city wasn't built like New York or Chicago's major metropolitan neighborhoods with all the infrastructure that should have been there. This was built as a small little town, and we're going to bust. And if we bust, then all these little businesses, are going to go out of business because people are going to do what they did in Chicago. They're going to move to suburbs because it's too much congestion, too much pollution, too expensive, and they're going to go out to the valley, and then this whole neighborhood is going to implode because all these people are coming here. And the city's not getting any tax money, so they're not helping us. And there shouldn't be...
Time is up. Thank you, Joyce. Jonathan Freeman, followed by G. Lafayette.
Hello, Honorable Commissioners. My name is Jonathan Freeman Anderson. I'm a resident of West Hollywood at 8110 Norton Avenue. I simply want to question the clarity of the ramifications of the interpretation. You mentioned you're afraid of it making your next door a long-term extended stay scenario. I'm worried because as an entertainer, I quite often find myself living in hotels and staying in my apartment and enjoy this less than year rental scenario I have on my lease, if the interpretation stands as it is and makes long-term ban the short-term prior to a year, I think you'll be seeing a lot of apartments clearing out, and many of the entertainers that travel on the road in this beautiful city having difficulty with their rental agreements with their landlords. I know I will. If I'm on the road for 6 months and I only have my lease for 6 months, what's going to happen with the way this interpretation stands? Does that make sense? Not at all?
I'm not following you.
Oh. Well, the point is I don't know if this is just strictly based on this building right here, or if this is going to extend to all the other buildings in this city. And I don't think that's been clarified.
Thank you. G. Lafayette, followed by Hector Barbosa.
Good evening. Can you hear me?
Yes.
That's too close. All right. Okay. Well, better you can hear me than you can't. Good evening, everyone. My name is G. Lafayette. I'm a resident of Los Angeles. I would like to vocalize my support for 8500's building. My understanding of it is that the end goal is going to be affordable housing for people. And with the provisions that I've heard today, the concepts of having someone there available 24/7 is to ensure safety and to provide assistance for maintenance issues, with the understanding of having someone check in to clean the houses or apartments weekly. I feel as though that would ensure the safety and security of the other residents by knowing what's going on in these houses that are being occupied. I think that with Western Hollywood being a place of diversity and progression, the issue should not be about resistance right now. It should be about cooperation, and it should be about being thorough with what we have and what we're doing. And I think with the affordable housing units being available to those who don't have the ability to pay utilities consistently, it would give us more resources to allocate back into the community and support others. I believe by having the facility compensate these people in this way, it would just simply recycle the resources that we're desperately in need of to begin. And from my perspective, it definitively needs clear guidelines, and it definitively needs to be more precise. But I think with our current housing crisis and what's going on in the world, these are the kind of steps we need to step forward and to not only take care of ourselves, but take care of our community and be the example that we would like to set in the world. And as far as having long-term leases and contracts, we all know in this day and age, with the current generations at hand, that's not always a reality. Somebody is not always going to be capable of being there, considering their work or other obligations. So I would like to again vocalize my support for 8500, and I would like to also support it being month to month, given the basis that we do not know what's going to happen and circumstances do change. And I think that working together and cooperating to chisel this down and have more specific guidelines would be the best course of action. Thank you.
Thank you. Hector Barbosa, followed by Chuck Justice.
Good evening to everyone. My name is Hector Barbosa, and I've been a resident of West Hollywood for the last 12 years. I live on 938 Palm Avenue, and one of the things that concerns me after hearing, from both sides today, is that I feel like there really hasn't been enough research, being made on what are the needs not only of the residents in West Hollywood, but also people from different parts of the country and the world who would like to be living in our city for a short extended period or any time that is necessary, particularly because we live in a city that caters to a lot of the people in the entertainment industry, a lot of artists, and just on our own experience at home, in the last 12 months, we've had 3 guests that have stayed with us for up to 3 months because there was no options for them. Hotels can get very expensive. And also, there's no, Airbnb was not an option in this at least in this community. And so we ended up, hosting, our house to our friends when even that wasn't their first choice. People need privacy, and that's what they were looking for, and they couldn't get it. what I think we have to look to into the future is that people more than ever are going to have very different needs depending on the different kinds of work that they do, which is very different than it was 50 years ago. My roommate right now, he's looking into where he's going to stay in 3 different cities in the next year for about from a month to 3 months, because his work can be done anywhere around the world. So he's going to have to look for these particular kinds of places also, in other parts of the world, not just, a question of being here in West Hollywood. So my thing is about more research and more study on what are the actual needs, regardless of who's going to profit from them. It's what's best for West Hollywood, its residents, and the people who would like to make it a part of West Hollywood. I think this is an incredible city. It's the one that I have lived the longest. I lived in Beverly Hills before and the Palisades, and those were not ideal to me. West Hollywood is, and there's reasons for that. The reasons is the diversity. It's a very progressive city, and what's important to me is that, seeing from my experience with friends and their needs, is that they have to have options. Thank you.
Thank you. Chuck Justice, followed by Bariva Rankin. Excuse me, I'm having trouble reading tonight. Chuck Justice, sorry, the next person after Mr. Justice is Martise Gilmore. Thank you.
Good evening, Commissioners. My name is Chuck Justice, and I live in Hollywood, California. And I brought with me petitions signed by over 200 people from the local area and business owners in support of the project under the original approved project. And what we would like to see is that those affordable units be provided for the families that are in need of housing and fulfilling the community with housing for people that need it. So all I want to say is thank you.
Thank you. Martise Gilmore, then followed by Bariva Rankin.
Good evening, all. My name is Martez Gilmore. No problem. I'm a freelance photographer. So one of the things that I love about West Hollywood, well, first, I'm from Los Angeles. One of the things that I love about West Hollywood is it is like a paradise. And so when I hear the back and forth that's been going on with the way that people are saying that they're hearing what the law has said, 31 days. Now, if I do a photography shoot and it says that I'm gonna get paid a certain amount of money and I can afford this place now, why wouldn't you guys allow me the paradise that you guys have been able to see? Other than that, it's just saying like, no, you're not good enough to be here if you can't afford the whole year. If you can only afford 2 months, if you can only afford 3 months, you can't afford to be here a whole year, then you're not good enough to be here. That doesn't sound right to me. That's not humane, saying that we don't want to put you somewhere even if you can afford it. This is what I'm hearing right now. This is all about interpretation, that everyone is going back and forth with what they are interpreting. And this is what I'm hearing, is you're not good enough if you're only making enough and you can only be here for 6 months. You can only be here for, 30 days, 31 days. But the law says that it's 31 days. So I am actually for the development. I think that it is a good cause for those that, and then you guys may even see like, well, we don't even want you in the area anyway. Well, I was only here for 31 days. That's a win for everybody, right? I was able to experience paradise, and now I can go back home to Mississippi somewhere, you know? Thank you guys so much. You guys have a great one.
Thank you, Martez. Bariva Rankin, followed by Lorenzo Brown.
Hello, my name is Bariva Rankin, and I'm a resident in West Hollywood, 720 Huntley. I just wanted to speak because I'm always an advocate of affordable housing. Definitely think that there's some technical parts that need to be worked out, but I live and struggle every day. And if there's an opportunity to make that easier for anybody else in the community, I think that's great, as long as it's benefiting the community. That's all I have to say. Thank you.
Thank you, Lorenzo Brown, followed by Melissa Nelson.
Good evening, Madam Chair, Commissioners. My name is Lorenzo Brown. I reside in LA right now. I'm seeking affordable housing in West Hollywood because of its diversity, its willingness to be accepting. I want to be here. The thing is that I don't make the type of money that you guys make to be living in homes as far as that goes. I need to have affordable housing. If not even affordable housing, I need to have flexible housing as far as that goes. And that goes to say that, is there any value to a 9-month lease? Is there any value to a 6-month lease? Is there any value to a 3-month lease? I would caution you guys on going with the recommendation or interpretation of the staff because it sets a precedence where in your city, you may have to now start litigating in different areas because of what the precedent is that you set, that you may choose to set that now has a year. You have to have a year lease, and that may not work for me. I may have to get a 6-month lease to get in to even be accepted. So I want you guys to take those things into consideration. Like I said, I'm supporting 8500 Sunset. I'm opposing the interpretation of the law that is being changed right now because the law does say 31 days. We need to throw that out. When does an extended stay become an actual, residency? At what point is that definition been brought up today? And I haven't heard it. Is it 2 months, 3 months, 4 months, 5 months, 6 months? You're going to blanket it as a year? Just think about it wisely, and I would advise you guys to proceed with caution. Thank you.
Thank you. Melissa Nelson, followed by Denise Brown.
Hi, my name is Melissa Nelson, and I'm for community housing of all kind, and I live in affordable housing. So, and I've been living in on this side of town for over 10 years, and I love it on this side of town, in over here in Hollywood. So, for to have affordable housing in West Hollywood, it would be nice. That's all I have to say.
Thank you. Wesley Bridle? Denise Brown, excuse me, and then Wesley Bridle. Because it's black, because it's dark, and I can't see it.
Was it Denise Brown first? I don't want to, okay.
Is Denise, is she here? Okay, then Wesley, it's your turn. Thank you.
Thank you, Commissioners. Wesley Brettel, West Hollywood. It's a ridiculous thing. I mean, you can come in and you can have a platypus and you can argue that it's not a mammal, but at the end of the day, it's a hotel. And I think that's the guiding fact here. We don't, I'm not going to say that we don't need hotels, but there's a process if you want a hotel. You can, and this wasn't the process. We have a deal. And so we need more housing. It's live, work, and play. To work and play, you also need to live here. Thank you.
Thank you. Are there any other individual speakers? I'm sorry, there's a little slip. Claudia Bastille?
Hello, my name is Claudia Badek, and I'm in support of the month-to-month because it's not extended stay. And I don't like to be locked into a lease because this is a city where the industry is changing constantly, and a lot of people come here to work, and they need a month-to-month. And a month-to-month is a suggestion that it's month-to-month, not just 31 days. So I have a hard time with having a year lease, and I'm in support of the month-to-month. And 8500 Sunset is not a quaint neighborhood. It's on Sunset Boulevard, and it's not a hotel. There's a huge difference between a hotel and a month-to-month. Thank you.
Ma'am?
Are you aware that what these what the applicant is, the appellant is charging for 32 days is $9,400.
Well, that's even more reason to give them a month to month, if you ask me. Because if somebody pays that much money, they're not gonna jeopardize the neighborhood. I don't think so.
Thank you. Okay, we still have a few more speakers. Zui Hare, is that, or Jare? They had to leave. Okay, John Fitzgerald Keitel?
Good evening. I've lived in West Hollywood since 1994.
Please just state your name, please,
Oh,
sir.
John
Thank
Keitel.
you. Thank you.
You said it so beautifully. So.
I got it.
I live right in the shadow of the project on Hacienda Place, and I've lived there since 1994, and have been in a relationship with West Hollywood since 1988 when I first moved here. And it's a little surreal to be here today addressing you again, because I was here to address you about the Airbnb issue. And so I'm just trying to reconcile the fact that as a how many ever years resident of West Hollywood, I can no longer rent out my place to, people. I guess I never could, but now it's really clear I can't, for 2 weeks at a time. Musicians from New York, filmmakers who are coming in, because that's against the law now. But we're going to have a 31-day, high-end, not a hotel up on Sunset Boulevard. And it just seems to fly in the face of why we founded this city in the first place, which was for stabilized rent. And I just wanted to bring that up because I think maybe we need to all take a step back, because I don't think maybe there's no such thing as coincidence. And the fact that these two issues are coming to a head this close together suggests that we've maybe lost our way here in West Hollywood. And we maybe need to revisit, amend, or come up with a new master plan about what we want our city to look like over the next 100 years. Because my feeling is, if this goes down, the paradise that the man rightly refers to might very well be gone. Because my knee-jerk reaction when I heard that's what's going to be done up there, you mean we've been dealing with this for 20 years and that's what it's going to be? I was like, that was just my reflexive act, and then I don't know all the history, but it's like, I feel like they just kind of came in and decided like we could make some money here. And the presentation didn't really give me a lot of confidence in that they couldn't even, like Airbnb couldn't or wouldn't, give us the information we needed to make an informed decision, couldn't even answer basic questions about how they make their coin off their website. And I don't know if that's because they just didn't know or if they're just papering over for our sake to make it look like a dog look like a cat, whatever it is. So I really think we as a city need to take a deep breath and think about what we want it to look like. My understanding is if you go along with the staff decision, it doesn't necessarily end it, but might give us time to start that process. Thank you.
Thank you. Victor Omolchenko, next up.
Good evening, Commissioners. I'm Victor Omolchenko, longtime West Hollywood resident, and wow, in a rent-stabilized apartment, may I add, and we've really contorted ourselves into a pretzel of semantics, as Commissioner Altschul mentioned, into definitions and that. I have to say that in the voluminous staff report, I am both fascinated and perplexed by Exhibit 5, in Supplemental Report 2 from the appellant, which provides some comparable statistics for apartment developments in the city. The Huxley on La Brea and the Dillon on Santa Monica move right in with a minimum 1-month lease. The Avalon on Santa Monica, where we used to have an older shopping center with 20 small neighborhood-serving businesses, move right in with a minimum 2-month lease. And then we have rent-stabilized apartment buildings in the city on such kinds of shorter-term leases. So, as a city, I don't know, to be telling AKA West Hollywood, the Corman communities, that they're operating like a hotel, it seems like all of these buildings that I just mentioned are operating like hotels. Where's code enforcement? I am very concerned about the precedent that could be set in approving the appeal and what that could entail. You know, West Hollywood is becoming more and more a city of transients, short-termers, longer-termers, and they come and go. They are not the ones who build community stability and spirit. More attention needs to be paid to the needs of the permanent residents of the city, the taxpayers, and the voters. We need new projects with housing that's affordable for the working and the middle class, and not just a few thrown-in low-income units into what are turning out to be luxury extended stay properties. Mixed use has been oversold, too many new hotels have been approved, and the city bureaucracy and elected officials are not solving the housing crisis by approving murky, mega development agreement projects. Thank you for listening.
Thank you. Are there any other individual speakers?
No individual speakers. We do have two people who chose not to speak. They are in support of staff's recommendation. That's Virginia Gillick and Kimberly Copeland. And we have one opposing staff's recommendation, and that is Rosa Lopez.
Okay. So now let's go to have the appellant come up for rebuttal. Is there someone who wants to speak for the appellant, please?
Chair, are we doing 5 or 10 minutes?
5 minutes.
Thank you.
Thank you again, Commissioners. I found the comments so interesting and illuminating from both sides. And the themes that came out to me were, somebody said some people don't know how to adhere to their agreements, and they were saying that against 8500 Sunset. And yet if we look at the agreement and we look at the ordinance that was in place, it could be said exactly the opposite. What comes up ultimately to me is the rule of law. And I know that there's incredible passion on both sides of this, and to the extent that there are people opposing 8500 Sunset, we have to understand this was a lawfully executed contract. We stand by it. We rely upon the ordinance as it was written, and that's something that's really important for us to be able to say here. I understand, I appreciate the emphasis on policy and philosophy and the way that the city feels about things. But fundamentally what matters was a viable, conscionable agreement entered into? And the answer is it was. And to change the rules of the game halfway through is not an appropriate thing to do. It's really important in our view that the Commission recognize that. And we can call it semantics all day long. It's easy to denigrate something as semantics when you're trying to get to a certain result. But the fact is, when our liberties and our rights are at stake because of somebody trying to change the terms of a contract, then semantics becomes very important. So the wording does matter. I just want to emphasize that it really is a privilege to be able to address you. I stand before you telling you emphatically that the ordinance means what we said. We can't just come up with one interpretation and then possibly a new one because we don't like the way, based on a sound philosophy or otherwise, that things are going to come out if we honor the agreement. Thank you very much.
Thank you. Commissioner?
I'm curious, and I hear your assertion that this is residential housing. But I'm very curious because this is a city that has been about residential housing since our founding day. Affordable housing, that is, if anybody knows anything about West Hollywood, that is our founding principle. So from a development agreement perspective, one of the things that I would say is you can get into the nitpicky bits of the law, and I'll let the lawyers do that, but let's talk about intent.
Sure.
And intent has always been about residential housing. So with that said, my question to you is, We have dozens of hoteliers who have written us letters and who are sitting in this room tonight, and bless you, we don't see you very often, so we know it's important. Why do you suppose that so many hoteliers in this city have written a letter in support of staff's recommendation and in opposition of your proposed business model?
So, Commissioner, I appreciate the question. You're asking me, of course, to speculate. I haven't spoken with them, and their motives may be wonderful and pure, or it's possible that their motives are they don't want competition.
Precisely. Why would they see you as competition if you're affordable housing?
No.
And you're residential housing?
I'll tell you why. Because somebody can decide they want to stay at a hotel as many days as they want. And if somebody decides they want to stay somewhere for 31 days and it's going to be a hotel, they'd rather have the business than giving it to somebody else. It's really simple.
So that would make you competition for a hotel?
It would make us competition for anybody, whatever you want to call it, where the person is staying for 31 days or more. I understand your look of confusion, but I'm telling you it's very simple. If you decide that you want to visit a city and you're going to be staying there, as many of the people did who spoke tonight, for 2 months. Let's say you've got a project as a photographer or an actor, as a director, and you want to stay somewhere for 2 months. Where are you going to stay? Maybe you'd end up staying at a hotel. You could otherwise stay at an AKA property. You're not allowing, if you're going to go with staff recommendation, you're not allowing that option to be given to people. That's not right.
So back to you're just a longer stay hotel?
No, of course not. You know, listen, that's really not appropriate. I shared with you your own ordinance dealing with hotel. It does not remotely capture AKA, period. I will engage with you. It's not a matter of lawyering. If you want to come and tell me how AKA fits within that, I'd love to hear it, because it doesn't work. Thank you, Commissioner.
Question for staff.
Thank you.
Are there any more questions for the applicant at this point? No. And then I'll close the public hearing, and we'll ask questions of staff or deliberate, or both.
20 years ago when we looked at this project, right? And we certified an EIR. And I might be venturing somewhere I shouldn't be venturing, but if you guys could humor me for a moment. You know, we looked at, you know, the EIR requires that we look at multiple alternatives. The alternative that we went with was condos and hotel, correct? Or apartment and hotel. Is that? Condos, right. And with condos come certain environmental impacts, correct? Traffic, noise, you know, whatever, right? I guess the question I have is, you know, this use, to me, is not residential in the sense that we've ever seen. This is a different kind of use, right? And part of the concern I have is that the EIR did not contemplate a use where someone's going to be there for a month and then leave. And I guess what I'm asking is that, does that have any merit, or is that a valid concern, i.e. that we didn't consider, you know, having, you know, short-term stays of 31 days, and then we consider this as, go ahead.
Basically, what I wanted to say was that they didn't contemplate this use particularly. So if we were to get an application, a request for entitlement for something of this nature, we would consider it to be a hotel. And specifically in terms of traffic, I'll speak to that as an example. The IT manual has extended stay hotel as a specific type of land use, and we would evaluate traffic based on that versus on a dwelling unit. So there's potentially different AM, PM peaks and different net trips, for example, that we would evaluate. And similarly with all of the other environmental factors, they may have different impacts.
I mean, without getting into the level of detail that you just described, and thank you for that. I mean, if I owned a unit in a building like this, or I rented in a building like this, would you say it's safe to assume that typically some people leave in the morning, come back at night, and that's it? Whereas someone who's staying for 31 days and is from out of town might be more, their activity might be more transient in nature, and the traffic and parking patterns might be different?
They would absolutely be different. I can't speak specifically
I
as to
understand.
when, but absolutely they're different. The numbers are different.
John? Oh, sorry, I have to tell my place.
Sean?
Lauren, isn't the purpose of a development agreement to abrogate or supersede the provisions of the code?
The purpose of the development agreement is to provide vesting to the developer and some certainty to the developer so that they can develop over a long period of time. And
Right.
it's a function of state law. It comes from state law.
But when there is when there is a specific way of developing in terms of use, does not the development agreement supersede what it says in the code?
Yes, the permitted uses and development standards are what's in the development agreement overlay zone.
Thank you.
Specified in the permit approvals.
So when it gets to court, it's in fact an interpretation of the development agreement.
Yes, that's what the interpretation is asking. Whether or not specifically, whether the dwelling units are being utilized, or whether they're being utilized as a hotel, are they not being rented on a long-term basis, and/or are they not being used as approved in contravention of the zoning ordinance and the development agreement and the entitlements?
Right. But is, in my interpretation of having sat here for 22 years, I was taught that in a situation like this, the development agreement language supersedes the code language, because what you're doing by a development agreement is giving the developer rights that he, she, it wouldn't have under the code.
It depends on what they're applying for.
Thank you.
Any other comments or questions? All right, who wants to go first? Okay, good, Stacy.
I'm going to volunteer this time. So I think I came in, first I just want to thank everybody, including the appellant and everyone present, members of the community, both residents and members of the hotel community. I always say this, but I stand by it, and that's that I never commit to making a decision before I hear what you have to say, so thank you. I came into this tonight thinking that kind of the crux of this was going to really be contingent upon how we define short and long-term housing. But I think in terms of staff's interpretation, where I am, at least at this point, inclined to agree with staff's interpretation, is that it's this third part, that this use is not being, this building is not being used as approved. You know, it's called an interpretation for a reason. There's your interpretation, and then there's the city's interpretation. But thinking back on this and having had discussions with so many people in the community about kind of the history of this project, I would argue that had the city known that the intent was to do this type of housing, that they would not have amended the DA in 2005 to grant you this use. And I think, you know, to Mr. Moore's point about, you know, Brookfield being very community-oriented, you know, you didn't ask or consult with the city about your intention to do this, either because you weren't aware that it might be interpreted to be in violation of your DA or because you didn't care. And I find your claim that there was no ambiguity to begin with, and this kind of incredulity that has been, I think, fairly present both in your communications and the staff report and tonight, or in your communications with staff and tonight, to be really kind of disingenuous. So at this point in time, I am inclined to side with staff's interpretation. And I don't think that there's a lot of, for me, it's pretty black and white.
I'll follow up with that.
Okay, go ahead.
And if you want to make a motion, I'll support it. You know, I take issue with two parts of this. One, and, plain and simple, this was intended to be housing. This is not housing. Now, I understand that that's a matter of interpretation. I tend to agree with the city's interpretation. And as a side note, Victor Omelshenko, I agree. We do need more, clean, affordable market rate housing that's actually housing for people that live and work here. I completely agree with what you're saying. And this project is not an example of that. And it's, in my opinion, it's a shame. Furthermore, to get just a bit more technical, I also believe that, the EIR at the time did not contemplate this type of use. And this type of use has entirely different environmental impacts. And for that reason alone, I absolutely, I would support staff's recommendation and would second Commissioner, I believe, Hoopengartner's motion. So with that.
We have a motion and a second on the floor, so we're going to be discussing the motion right at this point. Mr. Alschel, Commissioner Alschel, did you want to talk about the motion?
Yes, well, I think all of this conversation is about what was certainly anticipatable to be the motion. Mm-hmm. And my feeling is that it's headed for court. Denigrate semantics or not, semantics is an interpretation of language. And in my opinion, the language that is really paramount in this instance is the development agreement language. It's been over 20 years in the making, and I think your presentation here has been sort of on the fly. You're asked a question, A doesn't know the answer, but B comes up with the answer, but it may not apply to West Hollywood in all locations, but in this location it applies to West Hollywood, but it doesn't say anywhere that it applies to West Hollywood. So, this is a situation that can, I think, to a trier of fact, be sort of evident that, as they used to teach us in law school, in a lot of your analysis of this, the allegata doesn't meet the probata, or vice versa. And I, based on that, and knowing West Hollywood's long-term philosophy as it has always been practiced from 1985 until, and including today, we are looking for housing, long-term housing. We want people who are going to stay here, and we want people who are going to benefit and appreciate what this community has to offer. We try to craft all of our entitlements toward that goal, and this is something that's outside of the box. It may be something that, being outside of the box, we can obtain something valuable because it's already up in the air. I strongly recommend that somebody initiate a dialogue so that the court situation, which will cost somebody thousands and thousands of dollars, which admittedly you have, hundreds of thousands of dollars, which admittedly you have, and which probably admittedly we have, the city has. So this is something that I think should be avoided at all costs, and I think there are conversations where there can be benefit to the city along the city's philosophical lines, in addition to what would be beneficial to the appellant. But beside all that, and for those people who testified about how we're in favor of the appellant because we need affordable housing, $9,400 a month is not affordable housing. Our success in West Hollywood has been a blessing and not so much of a blessing. Our success has in some way kind of taken our core goals and our core ideals and put us in this position where we have to determine between the rich and the richer. It's a hard line, but determining either way. Hang on, listen to this one sentence. Determining in either way is not going to make this property what we call affordable. Thank you for coming. So I'm going to vote to support the staff's recommendation with the caveat and the hope that everybody sits down and gets this thing resolved in a very sensible way.
Thank you.
I too am going to support this motion. What it came down to for me is not the need of a project like that. I think that the argument tonight was made that there's probably a need for this within our community. What it comes down to for me is, was this project approved with that understanding? And I am without doubt that was not the case. I've read the minutes from the meetings where this was discussed. And I've heard the comments of the people who attended those meetings, and I have yet to hear anybody say this. And to put it into context, this development agreement was signed in 2005, and Airbnb wasn't even established until August of 2008. So this whole concept of these short-term rentals wasn't at all on anyone's mind, yours or ours, at the time this development agreement was signed. So I'm also stuck on the idea that, and I made a joke about it earlier, but I don't believe that everything that is not short is long. So I don't believe if it is not a short-term rental, it is a long-term rental. I believe that there is something in between, and I believe staff erred on, or excuse me, I said that incorrectly. I believe staff made the correct interpretation, looking at our code to get some guidance of what does long mean if we don't define it. And we can argue about that, and it could be semantics, but I believe it matters a great deal here. And I believe that simply because it is not short, it is not long. So this may not be a short-term rental, but I also believe that it is not a long-term rental. In addition, I do believe that the staff's recommendation is correct, that this is operating as a hotel. And I was really dismayed with the answers from the appellant tonight when, with literally written proof of how the lease process works with, and having gone through that, which I disclosed before you even spoke, I kept getting different answers every single time I asked the question, and by the end, I still didn't have an answer. I do know that if I were to reserve a room in any one of these other gentlemen's hotels tonight, that the email I get would be the understanding that I would have with their, I have confidence that that's the case. I guess I don't know it because I haven't tried it. I don't stay in hotels in West Hollywood because I live here. But one of the things the appellant said tonight was things are changing in how apartments are operating and how hotels are operating in response to one of our questions. And I believe that is true. And I believe that the city needs to look at this, and that is why I'm grateful that staff says that they're going to be bringing us a zone text amendment that's going to start addressing these things. They were not addressed in the short-term vacation rentals ordinance that the city council passed initially when I was a member of the public. The next time when I gave my opinion sitting here as a member of this board, this was not part of that conversation. And we are going to constantly need to be making changes in the near future, which brings me back to my original point. I believe that there's a need for this, but I believe that that we all made on both sides agreements to the public when this was approved in 2005. There was going to be one thing, and that we owe it to the community to keep that agreement, which is that this needs to be long-term housing, which is a year or more. That's where I'm at.
Did you want to comment before I do?
Yep. I think this is awful. The idea that while this case goes through courts, that building sits empty when there's a very real housing shortage in our city and our state is really disappointing. And I'm not a lawyer, I'm a designer, and I think we're sort of maybe more generalists, but as I listen to the lawyers pick apart the words, it seems unreasonable to me. I'm a renter, And in all my years of renting, I've never, ever been offered an opportunity for anything less than a one-year lease. And that's, what, 20 years of this? And then when you got the applicants trying to define themselves not as a hotel is so challenging in a hospitality climate that now has to redefine itself according to the advent of Airbnb and VRBO. Amenities vary greatly. IHG is branding new lines that offer very different amenities, offer longer stays, offer less amenities, offer cheaper rates. I mean, this is happening across the board. So, you know, what was the one speaker saying? It's a platypus, but it's a duck, but it's still a hotel. It's kind of like that. It's irrelevant to me. The fact that it's short-term stay. This, for me, it all goes back to the original development agreement. And if this had been proposed as 31 days or more, the low-income housing units would have never been calculated. And the fact that they were, to me, goes back to the reasonable idea that long-term or a lease is typically 1 year. When I was sitting with the applicants' representatives, we had a sincere conversation where I asked them, what is your typical renter in these shorter stay? And they said, typically people who are divorced, or maybe their houses are being remodeled, or their house is burned down, or their house has been flooded. And to me, that seemed reasonable to have that opportunity to provide housing for a particular group of people that fit into that category. And even the photographer that's in town for 2 months, yes, this could be a good option for them, but do we need 110 units? Like, I think one of the public speakers mentioned doing some real research as to what the market demands, responding to real demands in our market today. What do we need? Could we, if I was to broker this deal so that we don't have to go to court, I would, you know, I was thinking about this the other night, and I haven't discussed this with anybody, but if you use the same number, the same ratio to generate a low-income housing number, and then use that same number for shorter term, but let the rest of them all be at least 1 year, because we know that that is the majority of what is needed in the city. But it also offers an opportunity for unique situations like the photographer, or the person who works in the movie industry, or someone whose house is burned down and needs a place to stay. The fact that it's furnished, to me, kind of tips it in a different direction, because people who move to a neighborhood, who intend to stay, have furniture, have personal belongings, they change their address at the DMV, they register to vote. Someone who's there for 3 months likely does not. So, you know, this idea that BR Rep is community-oriented, I appreciate that, but I think the reality of this situation is very different. I mean, I'm leaning towards voting in support of staff report because of all these ideas.
Thank you. Lynn, have you not spoken? I'm sorry. You go first, I'll go last.
I was actually at all these hearings when this happened. I lived closer to that than I do now, but I was there. And this has always been about residential housing, always. Back to my earlier comment about the letter of the development agreement versus the intent. And I too agree with Commissioner Bass that, and I think it's Maya Angelou or somebody who said something about, see what are they actually doing versus what are they actually saying. And everywhere I went, and the website, how I too tried to rent a place, et cetera, et cetera. I didn't go all the way through the credit card part, but, and this is a hotel. And we are about residential housing. This agreement has always been about residential housing. As I said earlier, you know, residents change their mailing addresses. Residents move in grandma's china and the silver and the family photographs. And that's what this has always been intended to be. That was always the discussion in every meeting. And Mr. Altschul, you were at these meetings. That was the discussion, that was the intent, that was the agreement. And it was only the minor change that changed it from condos to apartments that's even facilitated this discussion, that they were condos. And this development agreement involved a lot of concessions on the part of the city to get that housing. It's one thing we haven't really talked about here, that development agreement was always about this housing and all of the hotels, all the benefits that the city would get. There was cash involved, et cetera. But to change that now, and to Commissioner Guy's point, it's a very real point about the EIR. You know, what is the impact of us suddenly changing the use of this space, and do we violate the law because the EIR that was related to this approval no longer serve? And with that, I think I've made my motion, and I would like to move that staff's recommendation be upheld. And that's my comments.
Okay, well, I think there's a pretty strong consensus here among the commissioners, and I think we spent a great deal of time on it, and we've been really thoughtful. I'm very proud of all of us, both everybody in the audience, and that we've really taken our time. We've looked at all the underlying issues, and I think that I hope that the applicant or appellant understands that we've been wanting to be very careful and very open in terms of hearing their argument and their issues. For me, it's been all along going back to the development agreement. And whether the ordinance says X, Y, or Z, the fact is that when this project was entitled, it was understood that these were going to be housing units and for housing. And at that time, we didn't have these short-term ideas, so it couldn't possibly have been our intent at that time to have anything like a short-term rental. It was always intended, and we wouldn't have had these affordable housing as part of it if it wasn't in the minds of the people that were dealing with this development agreement and the ordinance that was in effect at that time. So I'm very much in favor of moving this forward, and I think that I'm going to affirm the staff opinion and their interpretation. I'm very concerned. I think that the EIR issue is a very important one too, that really is very convincing in terms of this issue. It's very clear to me that this is extended stay hotel, and that's not what this was intended to be, and it certainly doesn't serve our community in the way that we intended when we originally approved the project. Question?
Can I just clarify what the motion is? There's a recommendation in the staff report that the Planning Commission, A, uphold the director's decision and deny the subject appeal, and B, find on a de novo basis that in contravention of the zoning ordinance, the applicable development agreement and project entitlements and dwelling units, A, are being used as a hotel, B, are not being rented on a long-term basis, and C, are not being used as approved. That's the staff recommendation, correct?
That is correct.
Okay.
Yes. So let's call the vote.
And the motion passes unanimously.
Thank you.
The resolution the Planning Commission just approved memorializes the Commission's final action on this matter. This action is subject to appeal to the City Council. Appeals must be submitted within 10 calendar days from this date to the City Clerk's office. Appeals must be in writing and accompanied by the required fees. The City Clerk's office can provide appeal forms and information about waiver of fees.
David, Will the minutes reflect a verbatim transcript?
Repeat that, please.
Will the minutes reflect a verbatim transcript?
Yes, the minutes will be verbatim by a court hearing, court clerk.
Thank you. Thank you very much, everybody. We're moving on to new business, which there is none. There's no unfinished business. There's nothing on excluded consent calendar. I believe our director, though, our planning manager update is going to deal with an issue that the commission has asked to come forward.
Can we have about 5 minutes while the room clears? Sue, can we have about 5 minutes?
We don't need 5 minutes for the room to clear. If you just walk out quietly, those of you who don't want to stay to hear about Bottega Louie, those of you who are still interested might want to stay put. Would you take your conversations outside the chamber, please? Thank you. Mr. Kehoe.
Thank you, Chair and member of the commissions. Member of the commission, you're not plural. So at the last meeting, a representative from WeHo West brought forward the issue about Bottega Louie and some changes in the design of the project. So I thought I would bring forward a brief overview of what has taken place at that location. So you may remember this is at 8936 to 8940 Santa Monica Boulevard. It was originally approved for a restaurant called Cooley's. That was originally a director approval that was appealed to the Planning Commission and ultimately appealed to the City Council. That project, the design for that project included both interior and outdoor space. It included an interior bar and an exterior bar on the back patio, and the back patio is the one that's adjacent to the alley and adjacent to the park. There were some concerns about noise impacts. One of the issues with it were noise impacts, and so the City Council did approve, they ultimately approved the project, and they did approve a condition of approval in there addressing noise mitigation at the back of the project. It says, prior to the issuance of any building permits, the applicant shall submit plans to incorporate glass within the rear outdoor patio area to address noise mitigation measures to the satisfaction of the Community Development Department Director. So subsequent to that approval, the restaurant site was taken over by Bottega Louie, and Bottega Louie came to the city and showed a different model for their restaurant floor plan and layout. It was a different design because it's a different operator would be using it. Instead of David Cooley, it's going to be the Bottega Louie folks. So that project included some significant design changes. It included reducing the outdoor patio on the rear by 49% in square footage. It included reducing the number of seats on the outdoor patio area by 22% and reduce the overall occupancy load of that area by 33%. A lot of that had to do with the fact that they totally eliminated the bar. There was going to be a bar on the back patio where people could both sit and stand and enjoy cocktails and beverages and that type of thing, and that was totally eliminated and removed. Another thing that was changed was the overall size of the patio was removed. They converted some of the patio to an interior storage area, I believe it is, so that helped reduce the size of that outdoor patio. Another thing that took place was the original design was in essence kind of a see-through building. It had doors that could completely remove on both the Santa Monica Boulevard side and the alley side. So if you're standing on Santa Monica, you could look straight through the venue all the way from one side to the other, and there would be a very, very large bar in the main part of Cooley's, and then you could look all the way through to the bar in the patio area next to the alley. They also, in this version, in the Bottega Louie version, they completely redid the interior bar. So instead of being a bar that was on all four sides, people could stand and get drinks and socialize, that's now only on one side. and I believe that only has 13 seats now. So that interior bar that under Cooley's had been a location for alcohol all the way around, now a lot of it is for pastries, as Bottega Louie is known for their pastries and that type of thing. So those were significant design changes that impacted, you know, the expected use of the restaurant. Instead of being a restaurant that was kind of alcohol focused with all those bar locations and the places for people to stand up and socialize, those are eliminated. All the places that had high top tables have been eliminated. So now all the tables in the venue are the typical tables that you would see at a dining location. So the design and emphasis of the restaurant has been changed from being kind of socializing and alcohol focused to more of a more traditional restaurant that has pastries. So in our review of that, we typically say when you're starting to reduce things, you're lowering the impact. Those are minor changes. So the concern was the outdoor patio. So the outdoor patio got smaller. The bar actually disappeared. Instead of having those open walls on both the front and back, they actually placed fixed glass. And so now there are doorways that open and close instead of having a roll-up door that could be open all the time. So that also provides another layer of changing how sound and noise transmits in that area. So those were all changes in the design of the project that we believed were minor and did not require that the director require any additional glass in the design. So that's the update on that project.
Do any commissioners have any questions about this? We did get a letter, Mr. Kehoe, from West Hollywood West Residents Association, and their concern is on the noise. And I know that there's been a reduced use in that back patio, and it's not going to be intended as a stand-up bar where there's a lot of probably more commotion and so forth. But when Mr. Cooley was here, we had some conditions placed on that space. And are those same conditions on Bottega Louie, or things changed now?
Well, like I indicated, the design of the building changed, so there are a lot of the same conditions in the report. Let's see if I can take a look at them. You know, so one of the conditions in the original one was that they reduced the scale of the front bar. So they did do that, and that's what I described. So that stayed because they reduced the front of the bar. And some of the other conditions would no longer really apply, but because they say the original one had no more than 10 tables, shall be over 36 inches in height, so they totally eliminated those tables. So they are basically complying with everything. I think the condition, my understanding of the condition of the concern was about the glass on the back, and that one was a condition that was subject to the director's satisfaction of the director, and that had to do with, you know, the overall changes in the project kind of compensated for, if the old plan had been adopted, then maybe there might have been some need for additional glass. But because the project had changed significantly on how the activity level would be on the back patio, we didn't feel that that was necessary.
I've been to Bottega Louie downtown several times, and it is very loud in there. You know, I don't know, it's different here. Huh? It's an old warehouse, and it's got tile floor and nothing to absorb the sound. So I'm just concerned, I know this isn't the tall ceiling and whatever, but it would seem that having them put the glass in the back, that wouldn't be such a burden on them, and it might reduce the amount of noise going into the park and back. So I just don't want to have some problems like we've had with Catch going forward. I just thought that.
Yeah, I checked in with code compliance today, and you know, the Abbey produces a lot of noise.
Yeah.
And code compliance has never received a complaint from patrons in the park regarding noise from the Abbey.
But they don't have a back patio.
They don't have a back patio, but they have a lot
patio.
of, they have people on the side.
They have patio in front on
And on the
Robertson.
side, right there.
And
right?
You're talking about 80 people, correct, in the back patio?
At
80 diners.
At capacity.
Yeah, 80 diners, then the bar, then the servers, all of the dishes. And I'm finding it very difficult to understand how that's not going to have a noise impact on a city park. And I guess my other question is back to the process. And West Hollywood West was very engaged in this process when it was Cooley's, and yet they were excluded from the process when the changes were made. And so I'm concerned, back to our conversation that we seem to have on a regular basis around here about transparency, I'm concerned about why there was no outreach to West Hollywood West when these changes were made, and how that is being addressed at this point.
Mr. Giesbrecht was intimately involved in the project. He came to the counter numerous times to talk to the planners, so he was fully aware of what was taking place. I'm not sure how he communicates to the members of his association. One thing an improvement that we have made recently that I'm sure some of the commissioners are aware of is our new info map. So we now have a live map that's on our website, on the planning and development side of our website, where you can go to our info map, and that has all the applications live, so you can see when someone applies for an amendment to their permit, and so you can see that it came in, and you can actually get notices. So if you want to sign up and get notices, you can do that. So that's a way for the community to become even more engaged. We've never had a process like that before for staff level approvals, because staff level approvals are just that. Those are approvals that are considered minor enough that they don't need that outreach and that type of thing. But now we've gone that extra step by providing a map where you can actually look and see all the applications that have come in for staff approval. And this also includes building permits as well.
So to be clear, West Hollywood West was involved with the decision to remove the glass?
No, I didn't say that. I said Mr. Giesbrecht. Mr. Giesbrecht
As president of West Hollywood
Mr.
West?
Giesbrecht, he represents himself as the president. He's come to the counter numerous times and talked to the planner about the changes that were going on. So he was aware that those changes were going on.
Okay.
Right.
But was not party to the decision?
No, because it's a staff approval.
Understood.
But I was just saying, you asked if they were aware. The president of the association was coming to us, and we were talking to them about the changes.
Okay. And about the precedent this will set for any other businesses around the park?
Every conditional use permit is a conditional use permit for that particular business, and every project can have conditions of approval established for that particular location.
You want to make that comment so that other people could hear that? Did you want to make a comment so that people could hear what you said?
I said translated, it means it sets no precedent. I said it sets no precedent.
Thank you. Next is public comment. Do we have speakers at this point?
Yes, we have two. Our first is Victor Omachenko.
Victor, please come forward.
Good evening again, Commissioners. Victor Omolchenko, longtime West Hollywood resident. I was pleased to hear Mr. Kehoe's update on the new Bodega Louis project. And, you know, what I've been learning is how important it is to stay on top of details, you know, what was intended as it's been discussed this evening and what has changed. And, you know, we now have a famous Catch restaurant just behind us at the corner of Belrose and San Vicente. It's being written up. But I was at the first meetings regarding it, and I remember when we're told by the city staff and the developers that the top of it would just be a sitting area for whatever kind of furnishings or carpet or whatever kind of store kind of evolved in that space. And over time, it evolved into this famous restaurant, but it caused concern on the part of neighbors in terms of noise. So what I wanted to say is that I really appreciate your focus on the concept of dwelling units, on the concept of intent in the development agreement that had been developed back, going to 2005 for the 8500 Sunset project. If your decision tonight, though, is appealed by this AKA West Hollywood group, your discussion this evening, your fascinating discussion this evening, has sparked some options in my mind that maybe could be used in some kind of a compromise, and it could be used to perhaps enhance our stock of affordable, longer-term residential housing. So I just wanted to share that with you. I know your next month is going to be chock full of 3 big meetings that were just announced in Thursday's Beverly Press, projects on Spalding, projects, I guess, on Romaine and elsewhere. I just wanted to give you a quick alert to a Monday meeting on April 23rd in the City Council's, in City Hall's conference room. I think that's where it's at. I don't want to give the wrong information. And it's about a project that's proposed for the 8000 to 8012 block of Fountain Avenue. And I just wanted to show it to you. It's a two-story buildings built in 1937, providing rent-stabilized housing, 17 units of it, at the southwest corner of Fountain and Laurel. And the community meeting is going to be next Monday, April 23rd, and the type is so tiny on this neighborhood meeting announcement. It's going to be in City Hall, in the small conference room there, and it's demolishing many rent-stabilized units for a really large kind of, I just don't know if it's going to fit in with the neighborhood in terms of compatibility, 4-story apartment building. So we all need to learn about what kind of concessions or waivers or what's being planned, and I plan to be there at the meeting on Monday, and I know several rent-stabilized tenants around the area there, too, are planning to be there, so it ought to be an interesting meeting. So thank you for your continuing work and your vote tonight.
Thank you. One other speaker. Come forward, please. 2 others?
Joyce Heftel.
Okay, we got another one.
Thank you. Joyce Heftel, long-term resident of West Hollywood. I thank you for your considered vote. Having been at all the Planning Commission meetings and City Council meetings with the approvals, it was never intended for this, never thought about that. To address what some concerns about going forward, perhaps because I've been here so long, some of you may not know that so many, the Grafton, the Chamberlain, the Park, the Standard, they initially were apartment buildings. Therefore, the plumbing for kitchens are in the walls of those buildings. Instead of allowing something like this to happen again, discussions with some of them to convert some of them to this shorter term living for the people with a fire, the people with da-da-da. They can accommodate that within their structure instead of having somebody else come and say, I want to build the short-term thing which takes away housing, because those properties are already there and not taking up land that's needed for housing because they already exist. So I think having discussions with those, I mean, there were, on Sunset, there was just one hotel and everything else was apartment buildings. So the kitchen availability is there, and the infrastructure can only take so much. We're feeling it now. I mean, we're going to have power shutoffs on Fountain to replace things, but the plumbing, everything else. This city was not planned like Chicago or New York, where there was an infrastructure that meant a lot of. This was a small, sleepy little town with little railroad worker houses, and the anticipation of who was going to live on each block were a few. I mean, I was here before the Ramada and the Ramada apartments, which, by the way, are short-term and have kitchens. So, I mean, to allow someone else to come in and apply for this, saying it's a much needed, it can be accommodated within the structures we have now, which will leave space for green and leave space for affordable housing. So I think that's a conversation you should start having with some of the hotels, because it won't be terribly expensive for them to put the kitchens back, because the plumbing and the gas and everything is already in the walls of those buildings. Thank you, and thank you for your vote.
Thank you. Richard Geisbert.
Richard Giesbrecht, President of West Hollywood West Residents Association. I would like to explain that I did go to the city and try to understand what happened with the Bottega Louis plans. I asked about the colors and the materials and wanted specific descriptions of them, found none, boxes were checked nonetheless. I asked about the ambient noise and the equipment that would serve it and where it was to be located. The box was checked, there was no information available. The planner could not provide that to me and in fact hadn't seen it. I asked about the lighting fixtures. The box had been checked, they looked at lighting fixtures, but there's nothing more than a little bit of ink on a piece of paper indicating what the light fixtures were. No further answers, no further specifications or anything like that. I asked about the acoustical report. I asked about the contradictions with the acoustical report, about the faulty scope of the acoustical report, about the conflicts that I saw within the acoustical report. I was told we don't really read the acoustical report, yet the box was checked that yes, indeed, there was an acoustical report. I had emailed John Kehoe for a meeting to explain where the glass wall was, because the planner at the counter repeatedly was not able to answer the question about what happened to the glass wall. I didn't get an answer from Mr. Kehoe, and the permit was issued. And I asked Mr. Kehoe for a meeting to find out what happened to the glass wall. In the 59th minute of a 1-hour meeting, Mr. Kehoe said it was done in a director's hearing, and he briefly said why. And I immediately said I felt that was an adequate justification to eliminate a central part of what we agreed to in the original Cooley's approval. That's what happened. But the permit had been issued. It was much harder to control the situation. How did that come about? Why was the planner not able to answer my questions at the counter? Why didn't someone pull out of the piles of documents this director's hearing and say, this is why? I don't know. I'd like to know. And as I said before, I don't like to be lied to. Thank you.
Chair, may I ask a question?
Yes, of course.
What director's hearing was this?
It was not a director's hearing. There was no director's hearing.
Okay.
It was a director's decision, which ultimately means it's a staff-approved project. There was no director's hearing.
Okay, thank you.
Okay. So everybody, we have had public comment. How about some items from commissioners? Anybody want to?
Joyce, thank you for making the comments that you made. My comment during my deliberation or my statement was, the hospitality industry is restructuring itself according to Airbnb and VRBO. And I think there is precedence. Everybody's kind of adjusting. Even IHG is introducing brands that have kitchens in them because they understand that the demand is changing. Their argument for hotel didn't fly with me because I can probably find a hotel brand that offers the same services or lack of services that they did in their argument. So they are a hotel, absolutely. But it's interesting that you bring up the fact that a lot of the hotels that are in existence in our city could readapt to provide that use to be helpful to people who are remodeling their homes, or homes burned down, or got flooded, or whatever it is, or want to spend 3-4 months in the city because they have a job here. I think it's worth the discussion, but not at that project, given the violation of the EIR.
Right. At this point, we don't allow even short-term, extended stay hotel rentals. I mean, it's not still considered short-term, right?
But in a hotel, could you do that?
That's
You know,
another
this
discussion.
This item is over and all the people have left, so I don't think we should get into a full-blown
Okay.
discussion about the item that had ended.
Thank you. Okay. So everybody.
I just want to say two things really quickly. One, the new info map is great, and I appreciate that. There was a project that you all approved, or half of you approved, when I was a resident in my neighborhood, and 2 doors down from me. And I keep getting these notices every time a building permit's put in. And Tony Castillo has been fantastic. I've sent him probably 15 emails. David's been copied on a bunch of them, just trying to make sure that they're actually holding to what was approved by all of you. The first time, all of you voted for it except for our chair, but I won't hold that against you. But you guys ended up approving it, and InfoMap lets me know when it's moving through the process. So I encourage residents to use that. I'm finding it very helpful. The other thing I want to say, just because our calendar now has June on there, I will not be here at either one of our meetings in June. First one for a work assignment, and the second one for a vacation. But I just wanted to say that out loud in advance of, since it's now on our anticipated calendar. I'd let staff know a few months ago.
Thank you. Anybody else want to speak? Okay, I want to thank everybody tonight. I think we all were very open about our view of this, and we discussed it. And I think I know for myself, I was a little confused about which way I was going to go, but I think after hearing the applicant, the staff report, discussion, a lot of people from the public, it became very clear, it just gelled. So I want to thank everyone for their participation. It was a good discussion. So we're going to adjourn now, the Planning Commission, to our regular scheduled meeting. Next meeting will be Thursday, May 3rd, 2018, starting here in this council chambers at 6:30 p.m. Thank you, everybody, and good night.